of the meeting is to review the joint plan with the NAACP. And I thought I have a few opening comments, and then I'm going to turn it over to Mr. Brown, but I thought it might be helpful if those of you on Teams might introduce yourselves so we know exactly who is who. We can hear Mr. Brown and Dr. Warrior's in our upper left corner. So feel free to introduce yourselves. Don't be shy.
Can you hear me? Can you hear Ms.
Yep.
Alma?
Say what?
Can you hear Ms. Alma?
We can hear you, yes.
I can hear.
Can you introduce yourselves?
Madam Secretary Raquel Wright was going to introduce all the executive members.
Okay, and maybe if you're on mute, it's best to be on mute unless you're speaking, but you can come off mute and just say hello.
The NAACP Executive Committee is as follows: Anthony Brown, President; Donald Hart, Vice President; Raquel Wright, Secretary; Kimberly Wright, Assistant Secretary; Kay Adelet, Treasurer; Ms. Alma Miller, Health Chair; Ms. Carol Pender, Education Chair;
Here.
Ms. Carol Bristol, Education Co-Chair;
Here.
Dr. Elizabeth Jackson, Civil Engagement Chair; Dr. Jacqueline Warrior, Education Emeritus; Aria Williams, Environmental Justice Chair; Reverend Benny Bryant, Religious Affairs Chair; Rashana Williams, Membership Chair; Steven Dean, Press and Publicity Chair; Victor Hart, Legal Redress Chair; and Julianne Price, Emergency Services Chair.
Thank you very much. I'm not going to presume that everybody on this call on Teams necessarily knows who all we are, but we might just quickly go around here, and if somebody is it'd be helpful if you would put your screens on mute. But I'm Brian Barefoot, and I'll hand it off.
Yeah, hi, I'm Terry Barenborg.
Good evening, Peggy Jones.
Hello, this is Jacqueline Rosario.
Mara Schiff.
Good evening, everybody. David Moore.
We got everybody. Ms. Dampierre, you can.
Come on, Pam.
Bass.
Reichman.
Rick Meyer.
All right. Well, thank you, everybody. I think in terms of logistics, this will be a bit of a challenge. It's always better to be in the same room, but we'll try our best. There is an I think of chat because I'm so used to Zoom, but if someone would like to speak, Kristen, what is the? We need our technology experts to explain the logistics here. If you all want to speak, which I'm sure you will.
May I say also that Mr. Fagan and I think when they put their mouths close to the microphone, we could hear really well. Otherwise, we get a lot of echoes the way the rest of you are sitting now.
Okay, that's helpful.
Okay, hello everyone. I'm Kristen Maddox, and we will handle this meeting like we did our board meetings when our board members were joining via Teams, and that was if you have a comment, if you type comment in the chat section. If you see that over to your right, if you don't have that pulled up, if you look at the top of your screen, there should be a little message icon. And if you click that, you can type comment. I have everyone's names on cards. And when Mr. Barefoot sees a card go up, he will acknowledge me, and then I will announce who has a comment.
Could you do that again, Kristen? That if we go to chat.
Yes, ma'am. Do you see the chat section?
Yes.
Okay, so you can type down at the bottom. It says type a new message. if you
Right.
type the word comment,
Okay,
I will hold up a piece of paper with your name on it, and Mr. Barefoot will acknowledge me, and I will announce who has the comment.
okay, thank you.
Does anyone have any questions? Okay, thank you.
We'll do our best to be very flexible here, and as we get used, and of course, you know, this is really a meeting to have a hopefully robust dialogue. It's not just comments, but some real conversation. And I would just say to start, and then I'm going to turn it over to Mr. Brown. This afternoon in our workshop, Mrs. Rosario reminded us of the timeline. And if you stop and think about it, since the August 2018 meeting, since that point in time, through all of 2019, during that period of time, the school districts had 3 superintendents, Rendell, Dr. Loxley, and then Dr. Moore joined us in December. In 2020, 2 months into his new assignment, we get hit with COVID. The Equity Committee, ably chaired by Mershawn Green, had some meetings during the course of 2020, but to my knowledge, the last meeting was probably maybe in September, October. So in many respects, there's not been a lot of consistent dialogue between the school board, the superintendent, and staff, and all of you. And what I know we all hope comes out of tonight is that we get a consensus perhaps on a few things, look for a path forward. We're all committed to the same goal, and as Dr. Warrior likes to say, and Dr. Moore, best by kids, in particular focusing on the African American children. We had a presentation earlier today, this afternoon, by Dr. Moore, and interestingly enough, in a couple of those slides that were put up, there's been some significant improvement, particularly as it relates to African American children. Now, one could say there should be improvement because the base has been low, but there has been significant improvement, and perhaps we'll have the opportunity tonight to highlight some of those things. But at this point in time, the agenda that has been put forth is really quite flexible. There are no time limits. In speaking with Dr. Warrior the other day, we thought it would be useful to review, in particular, the role of the Equity Committee, the NAACP, and the school district that comes out of the various meetings with judges. And hopefully you all received earlier today a copy of the document that talks about establishing the Equity Committee. But at this point in time, I would like to turn it over to Mr. Brown. Mr. Brown, why don't you take over and get us started in the meeting in whatever way you and your executive committee and others, Dr. Warrior, see fit. So so to speak, the floor is yours.
All right, good evening, everybody. I just wanted to thank Chairman Barefoot for this opportunity. First and foremost, I would like to respectfully request a slight change to the agenda, if it's okay with Chairman Barefoot.
By all means, we're very flexible.
What I would propose is we would like to have a discussion, not a presentation. We would like this to be facilitated by us. If you're in agreement, I will pass this process to Dr. Jacqueline Warrior, whose role is Special Assistant to the President regarding the 1967 desegregation order the 1994 agreement, the 2018 joint plan, and equity committee, and matters relating to education. Dr. Warrior has the full support of the Indian River County Branch Executive Committee. She has extensive knowledge of all the issues that are relative, and she's been a part of this DSEG journey from day one. With that, I'd like to relinquish myself to Dr. Warrior.
All right, we are here, and Dr. Warrior,
Yes, yes,
it's all yours.
it's all mine. As Tony said, and I'm going to try to be a little less formal now, but not do anything that's disrespectful to any of you. So I'm sort of giving me my new title with no new pay, though. And in an effort, I think, to distinguish, again, my work and what I'm doing, and that I do, speak in these times for our executive committee and for Tony. One of the reasons I did listen at the meeting, the workshop today, both live, and then I played it back to myself, because sometimes I, have to do that twice to try to get a sense of everything that's happened. In looking at the agenda for tonight, there's quite a bit on it, and I would be very pleased if we
Is now joining.
at least cover the piece on roles and responsibilities related to the joint plan.
I can't understand her.
In meeting with my executive committee last night, there was some question of, well, do we really need to amend the agenda? Don't we all know those roles and responsibilities? And, I know for one thing, as I listened at the meeting today, and I felt very anxious to sort of join in. And I feel like the board members, as I listened to them speak today, and I would say again, this is to be a conversation. If you have any issues that, you bring them up or we address them as we go. But I felt that each of you had a piece of the elephant, but not the whole elephant as you spoke today. I would make some amendments, Mrs. Rosario. You talked about the timeline. It was pretty close. Like actually, we held our first meeting, because if you look at the documents, and I've got legal documents and it was spread everywhere around me tonight, because I heard Mrs. Berenberg say, let's go by what the plans, and have to say. I see a hand up. Does that mean that someone is trying to make a comment?
No, it's just Alma Miller trying to see if we can eliminate that echo. Just about all of us who are online listening to you as well as whatever is in the room. And it is a very distracting echo.
Yeah, we're having the same problem here. There's a relay at echo.
Mrs. Miller, I responded to your comment in the chat section. If you have a pair of wired headphones that each of you could put in, it does help with the echo, because it would be on the end of the person who is speaking. Unfortunately, there's not much we can do on this end.
I do not, and I think everyone on the line is getting that same echo.
Right, yes, I understand. It's coming from the person who is speaking. It's coming from their connection, their microphone connection. Dr. Warrior, do you have any wired headphones that have a microphone in them?
I have wireless. I don't have any wired. No, I'm sorry.
Okay.
The echo is better. I mean, are you hearing a real echo when I speak?
It sounds better now.
If she stays close to the mic, it's better, without moving back.
I'm hearing more of an echo from the room than I am from Dr. Warrior.
Exactly.
Does it help if we mute it, if we're not speaking, if we can mute the?
I can't hear her now at all.
If everyone in the room could mute, then we wouldn't be hearing the feedback, I think, from them.
We're all muted in this room, so the closer you are to the microphone, the easier it is to hear, for sure.
So, well, we'll try again if it's problematic. I guess you can call it my attention. I mean, can you basically understand me or?
It's very low. Very low.
Don't worry,
It's
just
very
go
hard
ahead.
to
We'll
understand.
We'll fight through it.
Okay.
The last little bit when you were speaking, it was better than when you first started, but
Okay, is it better now?
yes.
Okay, I'll try to keep my voice up also. And just let me know if I tend to drift off. Sort of back to, but I hope what we can have tonight is a discussion, is a versus a presentation. I did watch the meeting today a couple of times. So I'd like to try to build off of what was said with your offering any clarifications, as you see fit, as I respond. I think our agenda, just in reference to it, is very aggressive tonight. And I believe after meeting with my executive committee last night, they wondered, well, why is and I informed them that that Mr. Barefoot said that we can change or flex the agenda tonight. We'll try to be very flexible, that this discussion is about trying to reach some agreement and some way about working together going forward more than it is about, I don't know, following every rule or protocol, but certainly making sure we stay within the scope of what it is we plan to do and within the scope of the meeting in the sunshine, kind of issues, that we don't violate anything. My executive committee, as I said, as I spoke with them last night, I was concerned, well, why do we have to spend time talking about roles and responsibilities? Because they thought that those were pretty clear. But as I heard the discussion, I was listening to the discussion today, I felt that they really aren't as clear as we thought. And I thought too, that we won't have to spend time. But I really, as I've thought about this since the meeting today, realized that the first 3 items on there are very, very critical, I think, to moving forward, or the first one on roles and responsibilities. And I know that I've had the conversation with probably Dr. Schiff and Mr. Barefoot about moving forward. Well, why can't everybody's anxious to do something? And I hear it. And I've never suggested that we aren't doing things. I've maybe sort of accused people of a lot of things, but being lazy is not one of them. But I think, again, we've made a lot of assumptions, and I'd like to try to clear those up as much as possible, and like to see if we can come to some place that says that we'll check out assumptions on some sort of basis. It doesn't have to be scheduled once a quarter or once a week, but as things start to accumulate, let's check out assumptions with each other. The question was, one of the questions I heard that was brought up as Mrs. Rosario tried to share a timeline with us. We actually met for the first time, and when I say we, let me get things because I've worn so many hats. I've served when I wasn't on the executive committee, I served on the first equity committee group. And we actually, if you look at document 140-1, if we want to get into the legal, that's on the docket, on the court docket. There's a real sort of timeline. And we were required by the joint plan. We were given a specific timeline by which we would meet. And we had our first meeting in December of 2018. And we came together at that point, and I think Dr. Rendell chaired that meeting. And that meeting was much as you do organizational meetings. It was, it was to bring the 4 members together and to elect a chair. And as I said, we can talk about timelines as we go along. One of the things in sort of setting up the meeting, and as I thought about it tonight, what would be the most constructive way to address it? And one of the things I thought was, and sort of facilitating a discussion, I'd like to be, that I'm going to try to put on hold my level of frustration, which certainly I know those people who've talked to me, reached out to me on an individual basis, has heard regarding how we move forward. And I'm going to try to keep all my narratives or sort of my judgmental pieces to myself and try to stay as factual as possible. As you said, Ms. Barenberg, at least that gives us a place to start. If we start with the legal documents and things that are in writing and things, it'll give us some place to start. And I think that we'll find as we look at just the legal documents, they're like a skeleton with no flesh on it and no sort of life breathed into them. But it's maybe the one place that we can agree with that we start. And sort of without doing a presentation, one of the things I'd like to say too is about the timeline. And I heard people saying, the discussion today was, with the second year or the third year. We really are. We're on different, as Dr. Moore pointed out. We're on sort of calendar times versus school year times. And one of the things I did very early on when we first got the joint plan was to draw up a little matrix for me, saying here's one piece that it's told us to do. What's the timeline for that? And that's been helpful for me to look at it. The other thing that I'm also aware of, as Tony stated, was part of the group that initially we started, and it was the approach to the district to let's start to talk about now with Dr. Rendell during his time, or at the end of Dr. Adams' time, which was even before Dr. Rendell. Let's sit down and really start to talk about the DSEG order because it still exists. And it's sort of lapsed, and we haven't done anything with it. And how do we move forward? Because there was some constructive pieces to it. At that time, decisions were made to approach it in a very different way than to sit down and try to talk about it. And sort of here we are today. But one thing is, I look back at this, and I sort of date it from about 2014, when we had the first group, because the first place we agreed to work was that the 1994 order had said that there needed to be a plan put in place for academic achievement, which now we call something like the African American Academic Achievement, just this long plan that's in place. And we've also talked about the fact that we put some pieces in the plan that we sort of merged some things, because the joint plan is different from the African American Achievement Plan. The African American Achievement Plan is in response to maybe one of 8 or 10 sections in the joint plan. And we've kind of pushed some of that together, and it may be helpful as we go on to separate that, so we're all in the same place about which one of these plans are we talking about, which document are we talking about. Because I heard a response today when someone asked about the plan, it was a response about something we had done in terms of the African American achievement process, which is different, and it can be confusing. One of the things that sort of strikes me most, and then we'll sort of agree on how we're going to move forward, or attempt to agree, were sort of two things I'd like to share. That if I look back at 2014, when we had the first sort of African American Achievement Plan, and it took us a long time before the district could even come up with a copy of the plan, because actually a plan was drafted back in 1994. And I thought it was horrible until we got until we come today to the struggles of what we have. Because actually back then, as I look at it, as bad as it was, I think it was much easier to deal with than the achievement plan as it exists today, and where we've gone forward. And so we've made a lot of changes, and sometimes we change only to go backwards. And it seems like we take a step forward, then we take a step backward, then we take, and we've just gone back and forth. So a lot of stuff has been done over the years, and this is not, sort of a brand new issue. But one of the things I thought about, I marked at least 2014, and it started a couple of years before that. Is now exiting. The kids who were in kindergarten then, if this really and truly is about the kids, are probably about ready to go into high school now. And here we sit talking about this as though, it's the first time that we've sat down. Many boards and many superintendents have struggled to some degree with this issue. And I know that one of the things that we'd like to do is to develop some continuity, to have some clarity. And the other thing that I was struck by was, and it's a brief story, and I'll tell it this time, and I won't repeat it over and over, was when I went on my internship when I was getting my degree. And so I interned at The Ohio State University. And for us, and this will maybe appeal to those of you who are sports fans, it's kind of like when you're, and you know, my background is my degree, my PhD is in clinical psych, that after about our fifth year, we put our names into universities where we wanted to do our final internship. And it was the last piece with, you know, approval of our dissertation. And then you waited on one day, graduate students all over the nation, seeing if their first or second choice had also chosen them to come to be an intern with our final act of you know, getting our degree. And as I went off to Ohio State, and I had my own reasons certainly for choosing that, and I got accepted. I applied, I got accepted, and I was excited. And they took 6 students yearly. And one of the things that happened when we got there was that 6 of us realized, and it didn't surprise us, we were 5 females and 1 male. It caused quite a stir among our primarily male faculty and internship mentors. And the talk about what they needed to do to balance it out. It had never been an issue when it turned out to be 5 men and 1 woman, but it became an issue when it was 5 women and men. Things didn't go very easily that first quarter. There was a lot of tension between the interns and the faculty. And it got so bad, at one point we decided among ourselves, interns, that we were going to confront our faculty. And our faculty said, okay, we're ready for you. And one of the things we agreed to do was lock ourselves one Friday into a room, and that we just agreed that we were not coming out of that room until we had resolved issues. And one of the things we were aware of was, as interns, we had a lot to lose if we upset our faculty and they decided to drop us from our internship. But they also realized that they couldn't wash out their 5 of their 6 candidates or of their selections, that the people that they picked not realizing what their sexuality was. And that was, and there was no facilitator. And it reminds me kind of us now. There was no official facilitator to tell us to be nice and play nice and do those things. The one thing we did commit to was staying there until we resolved something that each side could live with. But the interesting thing about it, a lot of people, we often say, we want to come out with this with a win. Well, one of the things that I've reflected over the years, because it was an unbelievably heated session. And the only agreements we had going in was that nobody would, you know, verbally attack in the sense of, you know, we're not going to cuss anybody out. We're not going to hit anybody. You know, we're not going to do those things. But otherwise, everything was up for grabs. And we would say it to each other. At one point, the male in the room got so upset by what was going on, he actually smashed his fist into the wall, and he got to step outside the room until he was calmed and he came back in. At the end of the day, believe it or not, and we got to a place where we thought it was going nowhere and we're going to kill each other, we came out with a resolution that provided a place where a number of us, although our faculty mostly did, you know, retired, except for me, because I was an older person in the group. I am retired. But we came out of it in a very different place. And in talking about it and trying to process, we realized that when we say we were all committed, we weren't committed to working, you know, to working something out. We didn't even want to come out of it with a win-win for everybody. But what we did realize, and what we felt like that was common, was that each one of us had so much to lose if we didn't resolve this issue, that we think we got to a place, and we've got some, and we get lifelong friendships out of it. And so, you know, that's a long way of just saying is more than coming out of this with everybody in the sense of everybody has to win. For me, it'll be going in, and I'll ask you to at least consider it. And I don't know what will motivate you, but to think is that we all have a lot to lose if we won't resolve this. And if we don't resolve it, somebody else can come in, because we've talked about repercussion to the district. And to be real frank, in many ways, I think it's interesting. Why is the district bothering to, or at times saying, we want to attain unitary status. Because actually none of the consequences, which could be significant, have ever been applied to the issue of this particular order that's, as we know, over 50 years old. But there are some real consequences. If we don't come to some place with this, the court will make a decision or a ruling. And as I think that people in this community, and I'm not just referring to the Black community, but the Indian River County community, have different reasons for wanting to attain unitary status. And what unitary status means, the court no longer has supervision, because whether the board likes that or not, you really are under supervision, but federal supervision because of the DSEG law. That's what happens. And the most drastic outcome of that is that there is the possibility that the court could actually put some sanctions on your federal funding. I think that is not maybe particularly likely, but there are some real sanctions. And in addition to that, whether you care about that as a sanction or not, it's going to be intervention from the outside, someone who may make calls and decisions that neither one of us like or can live with. And so as we said, and those are the realities. And we also would believe that we're in this, and I'm hoping that there's a group now, we're in a different place than we have been in before. Because before, we've been real clear, it's been about a win, a win situation. Who can win this? How do we come out from under the DSEG order versus how do we achieve unitary status? And so I'm going to go right now to let's talk about roles, and please jump in and help me here, because as I listened to the interaction today, I thought how much easier it would have been in the room then to have that discussion with sort of all people, at the table, to talk about what are our roles and responsibilities, and to put it in a way that is not that's not socially nice. And one of the things, I guess it was a week or two ago, and Dr. Moore and I had a phone conversation. And one of the things that I thought we agreed upon, but I can only speak for me, was that we weren't going to be mean and ugly to each other, but we were going to just try to be more honest and agree to be maybe more honest than we had been in the past. And I won't lay that on you, Dr. Moore. I'll say, for me, I felt I wanted to say some things that were honest, that may not be most socially correct to say, but that I thought got issues out there. And I hope that's, the kind of discussion we can have. And I always say this, then I go on, and the people who we've talked with for 2.5 hours, an hour, sort of know how these conversations go. But one of the things I'd like to refer to is a book. In my conversations with Mr. Barefoot, may I say Brian? Because that's what because we've agreed, that's what they call you when we talk, about a book, and it's called The 5 Dysfunctions of a Team. And I'm going to share this as a place for us to start. And I know this probably sounds like a presentation, and I'm real willing to hear, since I sort of said, let's have a discussion, I'm real willing to hear you say, pick your hand up and say, stop the presentation, let's get on to the discussion. But just quickly, in trying to frame this, is what I'm trying to do more than give a presentation. We talked about the 5 dysfunctions, the five dysfunctions of a team. And the first one is absence of trust. And we've all agreed, and we talk about that a lot, about how we think one of the things, or one of the significant things that impedes our ability to move forward and to come to some common understanding is that absence of trust. But the number 2 dysfunction is fear of conflict. And the number 3 dysfunction is lack of commitment. Number 4, avoidance of accountability. And number 5, inattention to results. And I'd encourage you, if you Google that or something, and just get a little bit more about that. And I even got the workbook, Mr. Barefoot, that's talk about overcoming the 5 dysfunctions of a team. I read after you told me the 5 dysfunctions, and then I thought, okay, so here they are. And it's really quite interesting. thing, although we really aren't in real terms, a team, that we don't meet the specific criteria. But a lot of these things, I think, all apply to what's going on for us. And it would maybe give us some common, language, because I know that Dr. Schiff talked about language and what we're trying to convey and how they mean different things. But it starts to give us some sort of common place to start. And so I have found this personally helpful in the discussion. So I'm going to stop with the fact to say is, if you look at it mostly, what's the role of the NAACP and the role of the school board? Well, in the legal terms is, the school board is the defendant in a legal process, and the NAACP is the plaintiff. The equity committee is a strange animal. And I don't know if anybody, it is a strange animal. We talk about it as though it's almost a third entity, and it really is not. The equity committee is a committee of the board. And what that means is, as someone read today, a part of the description around, they're going to look at and evaluate, and there was a lot of conflict around the two parties when we talked about what the name was going to be for the group. Because believe me, mediation became what would have been the summer of 2016 as we went into this, was very, very, it was very contentious. We didn't agree on anything. It was not good. The thing, and to say as we see mediation is the way to go. It is indeed a way to go, but it's not, I think, what many people think. First of all, a mediator cannot tell us anything that the mediator can't bind us to doing anything. The mediator's role is simply to sit with us, and for us during the mediation process, it happened to be a retired federal judge who was a friend of the Judge Williams, who's been assigned to the case. And so the thing that was said time and time again was he couldn't force us to do anything, because if we had not agreed on something, it would have been called what they call mediation busting, and it would have been thrown into the courts at that point for the court to tell us what we would do. And so, now as we think about these options, that's kind of the reality of it. And I think your attorney, which I don't recognize, but is in Ms. DeGresca's place, can, you can consult that person or not. So, so in Bear's terms, like I said, that's what we are. We're defendant and plaintiff. What I hope we look to do is to look somewhere beyond that. That's the legal definition of who we are. And so whatever the understandings or misunderstandings, like I said, back to the equity committee is a strange character. And I've often thought and said, and without adding anything to it, I think it's in many ways not been particularly helpful to it. Because one of the other things that I hear is that people say, well, we'll look to the equity committee. And I heard that today in the discussion. The equity committee's role is to monitor and do these things and make suggestions to us. I think that what we need to be aware of is that in the same way that by establishing and agreeing to the equity committee, that in no way changes the position of the NAACP. The NAACP is still the plaintiff in this case. Because if the equity committee had the same status as the board or the NAACP, they could only make recommendations to you. And then I've even gotten feedback was if I wanted some information from the NAACP, I had to take it to the equity committee. Well, I don't think so. And we could go to court and argue that if we want to, but I hope we'll get to a place with the understanding. The equity committee, and Ms. Green was one that said this more than once, cannot monitor itself. I mean, or the school board cannot use their own committee to say, to monitor them. So indeed, it is the NAACP that is your partner in this monitoring and compliance process. Because our agreeing to have this functioning, and it wasn't we didn't feel it was in our best interest from the firm, because again, it was your lawyers fought very avidly to have it report to the board and be a committee of the board, not as some separate entity, which one might think about in terms of an evaluation and compliance entity. It would not belong to the NAACP, nor would it belong to the school board, and we just do what we said we were going to do, and that body would monitor it and direct it, and the school board couldn't take that as a recommendation or anything else. It would be binding, because in the same way as accepting this group doesn't make your board cease to exist, it doesn't make the NAACP's role cease to exist either. And I think and so to me, it's a really strange board, because we say, okay, there are 2 members from the NAACP and there are 2 members from the school district. And then we act as though that's a level playing field. It is absolutely not. And one of the things that I think that I know that in discussions with the NAACP and our executive committee is our feeling, and I will own it, is my feeling, whatever makes it acceptable to you, is that the school district usually, our impression of the school district is though, you're going to tell us what to do, you say what you're not going to do, and you can do those, absolutely, but you're not the final say from that. You can just say to the court, I'm not going to do that, I'm not going to comply, but that doesn't mean that that's the last word on it. And so it makes me feel as though we're, a really teeny David in this whole fight with the Goliath, a district that has all the resources, that was willing to commit probably, at least we know, $750,000 to deal with the whole, and it was to get rid, it was to get out from under supervision of the court. And I hear from this group that it is not your intent, that you really do want to attain unitary status, which is something very different than just getting out from under the supervision of a court, nor to be held, accountable to anyone but yourself. So I'm saying, if you want to rescue yourself from a presentation and a discussion, somebody jump in here and let's start the discussion. Where do we start?
Hi, everyone. Dr. Jones here. Dr. Warrior, in one of our conversations, I wrote something down that you said. And you said the fundamental lack of agreement on the final product is what we are experiencing. We have a lack of agreement on the final product, that it's not the communication. We should identify the problem, resolve it, and let's not squander resources. So when you're talking about the final product, were you talking about the 4th Joint Status Plan?
I'm sorry, when I said final product.
You said one of the issues you thought that we were having is that it wasn't a communication issue, but a fundamental lack of agreement on the final product. What final product were you talking about? The 4th Joint Plan?
I'm sorry, the final product that I was talking about?
Yes.
Yeah, I always think the final product is that, besides the joint plan, is that we have incredible disparity in our district, and we all agree to that. And right now, specifically, we're talking about, for me, of all the areas that I'm most concerned about is academic achievement and the achievement gap between, Black kids and then the comparison of usually white kids. But if we're talking about diversity and equity, and keep getting me back on point. So I'm talking about an environment that really does do best by all kids, and that's not just a slogan. But one of the things I heard today was, besides diversity and inclusiveness and equity, was the thing that really touched me, was this whole idea of belonging. And I'm usually one that said, I'll settle for DEI, I'll settle for that. And belonging is a feeling thing that I'll wait till you feel like we belong, and the emotion piece. And let's just get to something that we can say, what's the law on this? I want to be able to live in a neighborhood where my kids can have the best schooling. And whether you want me to or not, I don't care how you feel about me as a Black family. And this was an experience for us, for us as a family, was not being able to live in neighborhoods because, I'd rather have the law that says you can't prevent me from living there than I want to feel that I'm going to have coffee with my non-Black neighbors. It's just like, give me the law. And so the product I'm saying is something that's a different environment for our kids that allows, and I'm not being specific, and keep pinning me down, down to this, is that I want to see some changes. I want to see academic achievement improve. And everybody will say, oh, yeah, I agree to it. And I guess that's how we get there. And what that means is the description. And I don't feel like I'm answering you completely, because I think, Dr. Jones, where I'm a little bit lost is when I said that and what the context was.
Well, I have a question. I asked Dr. Moore, who wrote the fourth joint status plan? Who wrote it? Tony or Dr. Warrior, do you know, or anyone remember?
Well, the process usually goes, and for the fourth joint, is that Dr. Moore wrote the first draft, sent it over to, and it's usually me, and then I'll mark it up and do all the red lining and stuff we do, and I'll send it back to him, and then he'll tell me what he doesn't like about what I just changed, and it went back and forth like that. Would that be a fairly accurate description, Dr. Moore?
That is kind of spot
Your mic, your mic.
I'm sorry. That is accurate.
And I'm just
Okay.
I'm just looking for a starting point, if you were, for this board. And you're absolutely right. No one sitting up here wants to say, okay, let's get out of that DSEC plan. That's not it at all. What we want to achieve are the goals that we're all looking for, our 4 areas of concern: academic achievement, the discipline and suspension ratio, also the ESE, and then recruiting African American teachers. So I just want to make sure wherever we start next, that we have that written very clearly. On Mr. Brown's agenda in December, he talked about what he wanted to see happen. A functioning equity committee that has inclusive and transparent manner, making sure that we establish the measurable goals, and making sure that we always have a status update to the court. And of course, we talked about trust there, but I can speak for myself, and other board members could speak, and Dr. Moore in this district. We want to move forward with those four areas, and how we define that as our equity committee moves forward, as they select our chair. We're in this for everybody, and we want our kids to be successful on all avenues.
Okay, may I suggest that I don't know where you came up with the 4 goals, because actually the joint plan has the areas that are listed on the agenda, and they're greater than the 4 that you
Right,
you had.
you're right.
Okay,
Yes,
so there are more than 4 goals, because to attain unitary status, we have to address things in each of these, what are there, 10 or 8 or something, 8, 9 areas.
Yes, ma'am. I was just doing a general consensus.
Okay, I'm sorry. Well, I didn't get, yeah. So there are more than 4 things I want, and the things we want, I guess, are pretty much outlined, by the joint plan. And remembering that the joint plan is that what I've heard Dr. Moore talk about before, not in a while, but a view from the 30,000 foot level. It's from that. It's that we want to have these things happen. And what we should, and that becomes a guiding skeleton. And what we should be doing is fleshing that out. What does that mean around student assignment? What are we talking about when we're talking about transportation? And certainly there are things that we spelled out in addition to this, and that you'll see probably out of the work of the Equity Committee as they move to use this for a guideline for the first annual report that they did at the end of the first functioning year. So what do we want? I mean, those are the kind of the things we want. And what do we want as a community? Because it feels kind of isolated sometimes to say, okay, Tony and Dr. Warrior, what do you want? Then it doesn't feel like we're kind of in this together. I think it's the sharing. What we want is a sharing of ideas, because when we tell you what we want and it doesn't work, and I think that's the thing that staggered us and has us still stuck back in September when we could not submit the 4th report, was kind of what we're talking about now, that there were some things presented from Dr. Moore. These are the things we've done. We've done a lot of things. And his concern when we said, no, we're not interested in those things. We're interested in the things that we thought we came out of 2019 agreeing, and the board had agreed upon, were that the things we would be moving towards. And I refer us back to a document, because I went back and dug through some 4 minutes to see what the board approved, what the board didn't approve. What Dr. Moore then gave us, and Dr. Moore, I'm speaking for you and you're in the room, so hold up your hand at any point, was he said, but we've done a lot of things. We've done a lot of good things. I don't want it to look like we've done nothing. And as I said earlier, I've never said that Dr. Moore, the staff, or anybody hasn't been busy. I've never accused you of being lazy, but what I'm saying is we thought we had some rules. After we came out at the end of 2019, we went through what we said. The equity committee made recommendations to the board. They met with the board in October. They tried to go through the things that are spelled out in the joint plan around the formation of the equity committee. There was a big, I call it kumbaya moment, where we felt elated because the board in the past had refused to speak with us. And that was the directive from the attorneys. Everything was funneled through the attorneys, the interpretations, I think we were probably a little more hands-on from the NAACP in the sense that Tony and I attended all of those negotiating meetings, and it was open to, if our executive committee, if they wanted to come. The position then was taken that board was not allowed to attend the meetings, and that was the directive from the attorneys. And because I was involved, I also know those discussions, not, certainly Mrs. DeGrasse, there's some of them confirmed, but that was a decision made. It was a decision made with Mr. Bukowski. And so your board did not come. And and that's another story. But I know that there were actual steps taken to not allow them to hear directly what was going on, but that it was from the attorneys. Why that decision was made, you'll have to ask something other than me. So we ended up then with the struggle in September being that Dr. Moore felt like was not measuring or was not saying we did this, we didn't do this, we complied with this, or we didn't. And he was saying, but we did this instead. And we said, but that's not what we agreed on. And so we're stuck back in September now. We've missed the annual report, and in March we'll be coming up with yet another report. And the court's now saying give us something, and it's also saying give us something on what is it, the 15th?
Hi, Dr. Warrior. This is Mrs. Rosario. How are you?
I'm well. How are you?
One of the things that you mentioned so many things that I would like to talk about, but right now at this moment, you mentioned about the fourth joint report that we either agreed or didn't agree to submit. We met as a group in December. And in December, when we met collectively, the board and the NAACP, it's my recollection that we all agreed, walked away from at that meeting, a brief narrative would be written up by Dr. Moore, and everybody was on the same page, that basically said, because of COVID, I'm totally summarizing, not much was done in the year of 2020. We left that meeting in December. Everybody agreed that that's what essentially would be written.
No.
The video would actually confirm that. And then Dr. Moore wrote the narrative to be submitted to the court, essentially saying, because of COVID, not much was done. Committee meetings, the committee did meet on occasion, but then that turned around. Then I believe feedback came to him in January that the narrative was not sufficient, that instead he was being asked to put the information in bullet style. And then, so the initial one about the COVID year, the brief that we were all on the same page with, now changed 2 and 3 times over. And so here we are saying we're still not in agreement, but in December we were in agreement on it. So the courts would have received that. So if so the process of if we're going to agree to something and submit the letter, What I think happened, if we're just going to talk about this, not historically, not going back, but just this alone, because one of the things you mentioned was that a letter wasn't sent forward, to the courts, the fourth joint status report. If we were to have sent the very brief thing that said because of COVID, summarize that, we would be talking about something completely different right now. We would be talking about moving forward goals to help set up the equity committee and so on and so forth. So how the information gets changed in terms of the formatting of the letter, I believe was a little bit of a delay in the process.
I certainly, I'm sorry, did you finish?
I did. I think we're just talking here, so I'd love to have your feedback on that.
I agree. A couple of things happened with that. I agree with you, and there's no disagreement that there was a 2-page document sent to the court saying that we had agreed on some things, and Tony did sign that. And I saw that because of various reasons, again, reviewing it in my role, in my relationship to both Tony and my executive committee, was to realize, gee, I don't remember all of these established agreements. So what I went back, and I suggest you might do it, I looked at that tape 3 times. Because if you remember that night, I was kicked out after being in, and so I was in and out. And I think Mr. Barefoot and I even, sort of laughed, and I thought, well, maybe it was all God's plan, but I wasn't there. I was quiet, and maybe things evolved. If you look back through it and go through that, you will find that a number of things were put on the table. And Dr. Moore says, well, I saw heads nodding and stuff. And that's one of the things I'm going to ask tonight and moving forward until we trust each other enough, not to believe that it must be the letter of the law and it can be nothing else. And so if I had not been ill, at the time and a number of things, and I'm not going to, offer that as an excuse, but it got signed. It never should have been, because those collaborative pieces, to have read that document closely, maybe, you can address Tony, and I know there's been this discussion about signing it. When you looked at it, those agreements that we had agreed to were not decided on. They were all things that were put out there. And Dr. Moore put out there, that, and I'm going to put it in, but it was put out there, let's not look at the COVID year, let's do some other things. That was never an agreement. And so there was some assumptions made, and I would invite you again to look at that, because I was real concerned and talked with Tony about it, and Tony looked at the issues and said he fell on the sword. Whether that's, adequate for you all or not, I guess it's, again, the thing that we look at. Those were not agreements. And moving forward, we should make agreements about some things, because the other thing that was brought up, and this is where we get caught up, I feel, is sort of a tit for tat. And I don't think you were doing that, Mr. Rosario. I think you were trying to seek clarification on sort of what did and moving forward. And so all I can say is that got signed off on, but those were never, when in review, those were never, and I did bring that issue up with Tony, saying, Tony, those weren't. And it was not appropriate for you to sign off on that without, feedback or whatever. And we can give you other documents where you as the board, and I'm looking at one, agreed in something in 2019 that was consensus was reached on, because it was dealt at a business meeting. And those things haven't happened either, Ms. Rosario. And so I don't know if you're asking me to clear up one issue or whether now we're in a back and forth banter between what has happened. You're right, the 2-page document went forward, but it was not what was stated, that we tossed the whole year. I mean, that's an absurd and I think a real inappropriate approach, and to agree to do that. If you look around at other districts, and I was looking at Palm Beach, and one of the things their superintendent said is, we must look at, and this was the stance I took that night, if you remember, Mr. Rosario, I said that I was very much against tossing, and you can look back at the meeting and see that I said, absolutely, we cannot toss that data, that we can acknowledge that we have 3/4 of the data, because we had most of the school year behind us before we went out. It was the last quarter that we dropped. And so to say we had no the board was told that we have no achievement data. No, we do have achievement data. The only data we don't have is the FSA. We have the iReady data. And I would know through talking and watching presentations from Ms. Dampierre, when she's been challenged, the teachers complain about iReady and whether it should be useful, that if I'm correct in hearing her say more than once, we use it because it's very predictive of how our students will do on the FSA. And so that's the value of that. How they perform on the iReady has a high correlation with how they tend to do on the FSA. And so they're able to take on more frequent readings and then use that, information. So I said, the board's not being given, so why throw out the information we have? All we have to do, it's not that the data, as we are was said in that document, is unreliable. And what was the other, I forget, not valid and unreliable. It is indeed reliable. And I know, it is something that we look at. We just acknowledge what it is. We acknowledge that the discipline data, for which shows a big reduction, in the number of students who or African-American students who were suspended, because the ratio used to be 5 to 1. If you remember that it was a 5 to 1 ratio for the same kinds of offenses for students. But you can change that in many different ways. And the way that was addressed was through a change. It was what I call a pencil change. It was a change in policy, not because it was a change in it. Well, and we can't say that, and the district can say it was because of our interventions and some other things. And we could set up some little ways to test that and see of how much of that is accurate. We could even statistically do it and model some of that information. But the reason those numbers dropped was because it was more of a systems change than anything else. It was also the fact that for one quarter's data would not be included just because kids were not in brick and mortar at the time. So it's not, so we could look at the data. And what Palm Beach said is that's very valid data. It'll tell us a lot. It'll tell us about how much the slide was. And these are discussions that may have happened, but I haven't heard them. This kind of meeting we're having tonight is the ones that isn't the one that interests me. It's looking at how much our kids felt. We know from projections and other people's work, and so I get very passionate about this, but I want to answer. So was that document signed? Yes. Was it fully, or did we agree and everybody understand? No, about it. So, if you want to hold, if you want to say, well, therefore we must move forward. And the reason we're stuck here, Dr. Warrior, is not because, because there's any real disagreement. It's because now you've changed your mind on what you want to do. So that's what it is. And I invite you, and I know you're one that looks back, you'll read the joint plan. I heard you say today, and read it part from it. But I asked you to look back and realize that there were no agreements such as, I guess until we learn to trust each other, we'll have to vote on everything and we'll have to repeat it and we'll have to make sure, because there have been a lot of issues around things that are said in meetings. And then when I see drafts of things, which usually come to me in my role to review, I just certainly have lead responsibility. That might include a number of other people for it. It just goes awry.
So
if I could just interject for a second, I know that Dr. Warrior and I have discussed this. I think there was a lot of recommendations, a lot of suggestions, a lot of ideas put forth at that December meeting. But in a real sense, Dr. Warrior is not wrong. It's that what people thought made sense didn't necessarily translate into an agreement. And I think that's where the confusion is. There are perhaps assumptions made. Everybody wants to assume whatever they assume to move forward. But I know that Dr. Warrior's probably looked at the tape of that a couple of times. I went back and looked at part of it, and when she pointed the difference between agreement and recommendations, and I think that we wanted to come out of that meeting with some conclusions, something of substance to move forward, and technically that's probably not exactly what happened, as well-intentioned as everybody was. But it's interesting that letter, my recollection, and I getting older, I don't remember as well as I used to, but that letter was really was signed off on. Not necessarily what it said, but signed off on by Michonne Green and Mr. Brown. And then the letter was written and ultimately signed, and it was sort of after the fact that what was put forth in that letter, perhaps people had second thoughts, particularly Dr. Warrior and even Mr. Brown. And I don't want to speak for Mr. Brown because we spoke about that letter. At any rate, there were a lot of very good ideas and constructive ideas, but that letter went. But it also said, excuse me, that the district would reply by the end of January with a quote-unquote update. And then, as we all recall, about, 2 weeks ago, we sent a letter to the court saying we haven't completed the update, my words, not what the letter said, but we will do so by the end of this week.
Yep.
And that's where we are. And we owe the court something that we can all agree on, really agree on, not suggestions or recommendations, so that we avoid perhaps the misunderstandings that took place the last time around.
Mr. Barefoot, if I could interject, going on what Dr. Warrior said, I did sign that document. It was a Friday morning. I had to come back and forth to the district office about 3 different times. I did not vet it good. And as I told you, Mr. Barefoot, as I told Dr. Baker Jones, I take responsibility for that, and I fell on the sword. But it did not reflect our intentions. So if anybody's to be blamed, it's the president of this branch. And that's a mistake that I will not make again, because I will read every word. I'll read it 3 times, 4 times, 5 times, because I trusted that the document was pure. In retrospect, I can't blame anybody but myself. So be it said, Ms. Rosario, I signed it. I signed it in error, and I take full responsibility.
So, thank you for that. I don't think anybody was seeking for an apology from you, but so that we can get to some substance by the end of today's meeting as to what are we going to submit to the court. So Mr. Barefoot is correct. At the end of this, other than going over the responsibilities of all of the parties involved, we still need something to submit. So what are your suggestions, Dr. Warrior, that you would want Dr. Moore to include in a letter, or what would you want in the letter to go to the court? What would that report reflect, in your opinion?
Okay, I provided feedback, and as organized as I thought I was, I provided some responses to feedback on the letter. At one point, it was like about 5 or 6 bullets, and then it expanded into 12 kinds of bullets. And let me just check here.
That information was shared with the board, so they should be familiar with that document.
Okay, good. I appreciate that. Because as organized as I seemed earlier in the meeting, I've now tossed papers around. But does anybody have a copy? If you give me a minute, I can find a copy of that, or we can go on and talk. Those are those things outlined. I mean, there's been no mystery about what I would think or like changes to see. So we can look at that document if you would like.
Okay, I'll pull mine up on my email, because I
Okay.
believe Dr. Moore sent it to us, and maybe if board members have the same thing, we could at least all leave here with something concrete, and that's what I think we just lost Dr. Warrior.
Well,
Oh, there she is.
I'm sorry. I didn't realize. I was trying to find my document so I could go through it.
Do you remember
I
the
think
date,
they're
Dr.
about
Moore?
Excuse me.
The 4th?
I'm just going to
November
lean
4th?
over here and try to find my copy.
February.
if somebody, so that we don't waste a lot of time, if somebody has a copy of it, maybe you can read it while I look for my copy.
I've got a copy of the 129 draft that Dr. Moore sent, and I have a copy of your response February 4th, if that's what you're referencing.
I think it is, there are probably about 10 or 12 points that I make there. Is that the document? Just, okay, hold on. I see that my first one that,
What's the title?
let's start then from this one, and then we can, you can help me fill in the others.
title
This
of
is the
the-
document where I said feedback on draft provided on the 25th, and then the later one, yes, would have been there. And so I started out with the first thing, so the period to be covered
Dr. Moore?
was one of the
Title?
first places. And that I asked for the period to be, that the period to be covered by the fourth
Yeah, I got that.
joint
This
status
one I'm
report
trying to look
should be
for.
March 2020 through
Yeah, I'm
September
looking for
of
it.
2020.
Yeah, okay.
That's
Thank
right.
you.
Is that right?
Yes, ma'am.
Okay, and the reason I asked for that was specifically, it gets bizarre now, given that we've gone almost, so many months beyond that. But that's what the court asked us for. And if you look back at the document where the court said, hey, you guys, you owe me something because we didn't respond. And I suggest that we respond in the future, no matter if we just say, Your Honor, we've done, this is, and not just not respond, because that's what we did in this case. Is that we agree on what the period is to be covered, because although we've talked about it, and one of the drafts that I said, it did come out with the issue of saying the joint status report would be for this period. But then as you read into the narrative on it, you see that then it covers everything through January, up through January this year. So it says two conflicting things. And I just wanted to be specific. And this is specific, as you said, is there to what the judge asked for. The judge asked for this status report, and that's what I'm assuming she still wants, because she hasn't told us any differently. And I'm saying we should limit the time for that. That doesn't mean that anything that's done past that won't be a problem, because, we also are behind on our annual report at this point. So we're behind, we're behind the gun on that. So that was the first thing that I asked. I said that there's no collaborative understanding, because I went back to just the words, that were utilized in the two-page report that we just discussed that went forth. That we talk about the impact, that we use the data, that we cannot. There's some very valuable information. And I'm not the only person holding that out. Certainly other districts are saying there's very valuable information. At any point, we can say that the data was limited to this date or that date.
So I think part of the confusion is that, the letter, maybe not some of the confusion, the letter or the information that needs to be sent to the court, this update is the status of where we stand as a district in the work of equity. But part of that has to be, had to have been feedback given to us from our equity committee. So if we look at the court order, it says, let me pull it up. And Dr. Warrior, we're on the same page here. But we're on the same page, Dr. Warrior. So, but the equity committee is responsible for providing to the board their recommendations. The committee has the authority to recommend goals and benchmarks to the school board for progress. So essentially, as they meet throughout the year and they review data, they review how we are implementing the works of the plan in its entirety, not just academics, but also in the areas of transportation, human resources, the mentoring components, all of those sections that are listed in the joint plan. That is the work of the equity committee. The equity committee would then provide in their advisory capacity their recommendations to the board. And then on page 2 of the joint plan, the second to last paragraph reads, "The school board may delegate to the equity committee the responsibility for preparing and submitting to the court by the second Monday in December of each year a report regarding the status of the school district's progress in achieving full unitary status." What we
Okay,
have done,
I think I'm going to ask you respectfully, may I interrupt? But I think you're looking at the other thing. There's the joint plan, there's the order. If you look back to the judge's order.
I am
which is
looking
the
at
two
it.
page- No, you're looking at the joint plan. That's two different documents, Mrs. Rosario. There's another that's very, like, only 2 pages. And it says, it is ordered and adjudged as follows. And one of the things it says that the parties shall follow joint status. This is not about the evaluation. You're talking about another piece. And this is where it gets confusing. And this is why I said I drew out for myself this sort of matrix that talks about all these little pieces and all these dates because there are all these plans.
No,
But it says the parties shall file a joint status report every 6 months, advising on the progress of the goals set forth in the plan.
right.
And so that's a very brief. That is not. Oh, thank you there. Appreciate it. I just found it. So thank you though. And so what you're talking about is probably maybe since we haven't even gotten to the annual plan, what you're talking about. But this was to be a status report because what had been requested was a yearly update to the judge. When the judge finally confirmed that she was, ordering, and it is further ordered and adjudged.
Mm-hmm.
And it talks about some other things there that we've not addressed, but that, okay, yeah, it's up there. That what we're talking about is it's not the evaluative phase. It's like, given this 6 months, it should build on the previous 6 months. In a 6-month plan, my interpretation is we should agree to this is what we hope to accomplish in the following 6 months. And that all we have to do is then say between March, the report filed, the one filed before this, the third report, should have talked about where we would go and moving forward. Then this report simply should address what progress have we made on those things that we say we're doing to have the joint plan. So I'm suggesting that what you're getting into now is much more needed than what's needed in the 6-month plan. It doesn't need to be as long as the annual report.
I hear you, and I think that you're right. There are 2 different reports here, but how we began this conversation was talking about, or this part of the conversation was talking about the report, the end of the year annual report that needed to be submitted in December that ultimately wasn't, which is what is now due this week.
No, that's not true.
At the end of this week, what is the date that it's supposed to do? When is it due now? This Friday. So there's 2 different, the 6-month goals report is not the one that's due on this Friday. What is due on this Friday is the annual report.
No, that's not true. What's due this Friday is the 6-month report. The judge hasn't even dealt with us on the 12-month report yet.
Okay.
Because what her order says, and the lawyer's there, what Mr. Grester read to you all was, in the document that we have, it says, I'm still waiting for my 6-month report.
Sorry, Dr. Warrior, if you don't mind, I'm going to ask our attorney to clarify.
Absolutely.
Because
Absolutely.
as far as we've been talking about the annual. Everything has been the 4th annual report. That has been the report that has not been sent in because it keeps going back and forth. So now Dr. Warrior's mentioned, I'm just looking at Dr. Moore right now as I'm speaking out loud. And now we're hearing of a 6-month report. But at this point, may I ask legal, please, if you can please confirm, because what we have, well, you heard the whole thing. So what is due this Friday, please?
The annual report. The annual report is due,
This Friday,
yes.
not the 6-month report.
No.
Okay, so it is true.
What
Dr. Moore?
Yeah, just for a level of clarity. the letter that was signed and sent to the court, it informed the judge. She asked for information, and she said, in my presence, if you know, the NAACP and the school board agree on something, then, you know, we just need to inform her. Prior to December 21st, I think was the date, she had to have that letter. Mr. Brown already spoken about that particular letter. In that letter, we said we would file the 4th joint status with the annual review. So the interpretation at that particular meeting was that we would be very condensed in completing both the outstanding tasks to fulfill the court in order to move the work forward. That is not the reality that we face now. Dr. Warrior has suggested or did not agree from the onset that they should be combined as stated within the signed letter. So if you look at what's on the screen now, the recommendation is to bifurcate the two, which is initially how it would be, which would be the work that was, the progress that was made by the school system in March to September, and then the annual report, which is the progress that the equity committee would make. And we run into the dilemma because at that joint meeting, the equity committee made the decision to sunset that committee. Pam, please step outside. It's okay. It's fine. To not fulfill that, I don't want to say evaluation, but provide a review of the work to provide the progress to the school board and then ultimately the court. So that really is the dilemma in which we find ourselves. If we collectively agree, hey, we are going to provide a status report as requested by Dr. Warrior, which solely speaks of the progress the district has made from March to September. We got one agreement, if that would be the case. Still outstanding would be that progress for the calendar year 2020. So how we would accomplish that, yet to be determined. I just kind of want to caution us on the work forward and our desire to get to that particular work. And that's why what I tried to communicate at the initial meeting, let's get into this work. And if we come to the agreement that we say, hey, you know what, remove the timeline, extend it for a year because COVID wasn't where it didn't allow us to implement correctly, priorities shifted, we did A, B, C, and D, that's fine. And to be quite honest, this for me or anyone on the call or on this board is about trying to get out from underneath. It just irks me every time that I hear that. We're not trying to get out from underneath or get away or achieve unitary status. We are trying to transform what teaching and learning looks like in the school district of Indian River County and drastically accelerating the performance of African American students who are sitting in our classrooms today. And that's not a one-year project or a three-year project. So if we can say, hey, you know what, let's remove that. Let's tell the courts, you know, we want to extend it at least one more year because you know what? 2020 was not a year that allowed us to make the progress that we wanted to make. And if the NAACP and school board agreed upon that, okay, perfect. That could be an agreement. And as I have said publicly many times, Mr. Brown calls them tweaks. There are a number of things within the plan that I have a hard time digesting because I don't think they're in the best interest of children. And some of the frustrations that I have, just David Moore speaking, is how some of these goals are written. I don't think they're in service of children. I think that they're very, you know, we should make every effort. I'm trying to turn to how some of these things.
Well, yeah, but may I clarify one thing back to the fact that I think your attorney said that it is the annual report that's expected. I'm referring to document 148. It's been filed by the court, and the order requiring a status report from judge signed by Judge Williams said the parties did not file their fourth joint status report by September 13th. And then it goes on, and then it talks about us explaining. But then what the judge says in what it is ordered and adjudicated by no later than December 21st. The parties shall file the joint status report describing the efforts they have taken to resolve their disagreements regarding the organization, structure, and content of the fourth joint status report, and advising the court as to when the parties expect to complete and file the fourth joint status report. This is not, I'm just going to suggest to your attorney that she look at that and say that we're required to file the annual report. It is the fourth joint status report as laid out, and one of the things Ms. Berenborn has suggested today was that until we decide and flesh out some other things, that we go with what the court has requested. And this is a copy that you probably already have. If you can't, you can go on Pacer and download that document. And that's the judge's thing. That's not Dr. Warrior's interpretation of whether it's the annual report or not. It's the fourth joint status report. And in the previous document it had up there, it talked about what that was to be. And so I disagree with that. It's a, assumption that that the judge is expecting the annual report. And thank God she's not, because we're not prepared to give it because we haven't evaluated. Maybe we could be prepared to give the fourth report that we did it. So to be accurate on this is not I guess it's Dr. Warrior's interpretation that she meant the fourth joint status report when she filed it. But I direct you, you've got your computer, log on to Pacer and pull down document 148. And it's the one Mr. Gresta read to us when we found out that the judge had said you need to get something, to me.
And I agree with that, and I think the letter that we jointly signed and sent in December gave the judge a level of comfort because we informed her in that letter that we would send the letter by the end of January and then by the end of February. But in that communication that we are no longer in consensus but was sent to the courts, it was informed that we would send the fourth joint status report with the annual review. So it may be, and none of us can read the mind of the judge, but what we did in fact inform the judge is that we were going to submit both of those documentations combined. Now that's not to say that we say, hey, you know what? Because as you and I both know, she's not too patient in terms of waiting for the required documentation that's defined within the order that she has issued. Hence the letter that came in December. Now we did notify her, hey, we are continuing to work on it. She got tired of waiting and asked for the information to be sent by December, which we did. But in that letter, and then again in January, we notified her that these things would be coming together. So what is due to her by this Friday is information regarding where we currently stand and or the fourth joint status. And if it is the agreement, and once we get to a point where we're having agreements, we'll put up, we'll have someone scribe what these agreements are, Dr. Warrior, an executive committee, so everyone can actually see them written in real time. So when we log off at whatever time that is tonight, there's no misinterpretation. We can read them and be clear as in terms of what those agreements would be. But if it is to file here's what happened between March and September, and here still the outlier would be the annual recommendations regarding unitary status within each of the sections. And that could be deferred back to, not that I want to put any additional work on our incoming equity committee. I really would like and think a part of the solution is to move the work forward. But that could be something that would be completed by the equity committee, which would be looking at the documentation that now, by the time they come together, that may be asking too much because it's a significant amount of work that they would have to review going over the course of an entire year, with 3 of them being new, and then ultimately also provide, we have to provide an update, and we would like, my recommendation is that we ask the Equity Committee to provide a recommendation in March of the work that we have done aligned to the joint plan in March. And I think that process moves us away from a level of unclarity regarding who is doing what, but allowing the Equity Committee to, meet in very, very early March, look at the work that was done in January, February, and then come back to this body of individuals, school board, and provide their recommendations to us in the presence of all. Might make that work a little bit more streamlined.
I have a
You
suggestion.
see, one of the things that's happened here is now we've, and I wish if I had known this was going to be the topic for discussion tonight, and I'm okay with going free form, but I would have invited, and maybe she was, Ms. Green, to come back, because actually the Equity Committee was ready last, at the end of the year when they normally do the report, because of it being on the calendar year. At that point, to start the night, and we can go back and look at the video of that. They were ready to start doing the evaluation piece then. Dr. Moore said that then you intervened and said, wait, you don't have all the data. And we said, but wait a minute, the door is closed. We talk about a time. You suggested that the data libraries where the information was supposed to be. We closed it, we looked at it, we assessed it, we evaluated it, and I looked at the data of that. Then the Equity Committee was ready to start doing the evaluation. And there was a thing then, well, nope, we're not going to do it now because we've got some other data. And we're saying, but if that was true, we have to close. It's like closing the books on your business. At some point you agree in this year is when we close and we evaluate. And at the point in which the Equity Committee was doing that, and we can go back and look at those data libraries. And that's one of the things we've really pushed. And I think some of the board members have looked at them and some have not, about what's contained in those data libraries. The process was stopped at that point because Dr. Moore, you said there was a lot of data we didn't have, or that the committee didn't have. And so now we're going into a discussion we need to have. It is different from the one we started with, but yet it also is playing out before you the kinds of issues. Who gets to call this? Who gets to call that? What's the role? What's the responsibility? Who can stop what? And that's where we.
This is crazy.
That's where we
still have a report. We still have a report.
Dr. Warrior, one of the things I'd like to add is this discussion has just shown us the dysfunctionality of the process. We have went all over the place when the question was the joint status report. If all board members would look at all their emails relative to this, it stated the 4th joint status report. I've been looking over my stuff on my computer. We now have transferred from the 4th status report to the annual report. Nowhere in the joint plan or the court order that they were to be combined. So this is where we get off cue when we mix apples and oranges. The joint status report is what we have been talking about. Get it done, get it in. Now we've jumped ahead, and I thank you, Dr. Warrior, because I wish Mrs. DeGresta was here or our attorney had tuned in, because it does not say that we are supposed to be doing the annual report. We're still stuck on joint status report.
One of the things I think one of the things they're saying is that we're beyond that because you signed off on the document saying they could be combined, and that's where we're stuck because of this. They're saying that you signed it off, and it was sent to the court, and that's the expectation now, and that's where we're stuck. How we resolve.
If we could come to consensus, just to, are we at? And I think I don't want to speak for the NAACP, but if we're in a situation that what was, for whatever reason, place blame nowhere, but what was sent to the judge didn't represent that meeting that took place in December, and now we're going to provide just the status update for the 4th joint status report, which is the work that was done from March to September. All in favor, say
Right.
aye.
Aye. But I just want to clarify, it was my understanding that the fourth joint status report was the annual report. So
No,
if that
I-
was not accurate,
No.
please accept my apologies for using the wrong words, because I don't want to get accused of not reading my email. I do want to turn to legal, our legal right now, and just clarify. Can you please clarify for that for me? Is the fourth joint status report the same as the annual report, or are those two separate reports?
I think the confusion was that they were put into one because of the timing, because the fourth joint status
That's,
report
okay,
got moved back.
thank you.
Yeah.
That's exactly what I thought.
And we do, by the way, we do have a fifth joint status report due March 13th as
Thank
well.
you. Let's,
Thank
So-
you.
Just
so we-
wanted to,
Yeah,
We've been,
thank you so
everybody's,
much.
we're going back and forth here, but from a practical standpoint, if this was our business, which it is, I frankly don't understand, given the timeframes involved, why combining, which is what we're discussing, the fourth update and the annual report, which was the 129 draft that Dr. Moore sent for feedback, and that's the feedback you got from Dr. Warrior. Here we are, the 9th of February. We're a month away from owing the court the fifth report, which means if we're going to do the March to September timeframe, then we have to do another one that's the annual, and then a month from now we produce the first quarter. It doesn't make any sense, personally. I think we've got to come to agreement with Dr. Warrior and Mr. Jones. As much as it may seem not by, I don't even know what the right choice of words are, but the practical solution is that the reports be combined. And let's take the first quarter of this year, January, February, and get the information to the court on the time schedule that they expect, which is mid-March. All you're going to do is take this report, and you're going to pull out of this which relates to the 6 months, and you're going to leave everything else there. I don't know.
Dr. Warrior, Mr. Brown, is there any consideration to notify the court, and I will summarize, that based on the lack of trust, the lack of structure, COVID-19, the things that took place during the year of 2020, we would like to add a year to the implementation of this work and begin with our first implementation going in March. So almost saying, because we were unsuccessful, blame it to our heads, not our heart, in doing this work for a number of reasons, placing blame nowhere. We acknowledge that this dysfunction, but are committed to moving forward in a way. I honestly, wholeheartedly believe if we can get into the current reality, some of this work becomes easier. So I'm asking, is there any consideration to say, let's add a year or request in the joint plan, rather than be conclude at the end of this calendar year, have it conclude in the end of the 21 calendar year if the appropriate progress is being made. 22, okay, I've lost a year. The end of 22, if, when the equity committee is fulfilling that role, the appropriate year is being made. Is there any consideration to consider that?
Well, a couple of things I'll say. You're talking about, and I don't know when you say the third year, because it was clear from the court when we were in mediation that 3 years talked about the equity committee. It did not talk about, I mean, it doesn't remove anything else. We are bound until, we comply with the segregation order. The court will continue supervision. The only thing that was written in this document was something about a 3-year term. And I think that was really misleading, the way it got into there, because the 3 years isn't a drop dead time. The 3 years might be at which the equity committee goes away. And you know, that could be a good thing, who knows? And the district said, but we'll do it for 3 years. The 3-year term, I'm not sure what people are interpreting that to mean. It's not implementation. It's like, have you complied with all the requirements that the DSEC ordered, the way it stands now, you know you have to do, and it doesn't happen in 3 years, because if we look at other court cases that once you know that we're complying with everything, the court then gives a year, and it's been negotiated between the parties. Is it 2 years? Is it 5 years of continued compliance before a unitary status is addressed? So I think some things have really gotten mixed up and confused, and you know, given what it was said about the 3 year, because I find that interesting. I don't know what the third year you're talking about is. I mean, that's kind of irrelevant until there's compliance.
So maybe I could, I'm looking at the order now, and what it says, on the purpose and mission, therefore, the Equity Committee will monitor the school district for a period of 3 school years, which time period will begin at the Equity Committee's first meeting. If at the end of 3 years, the school district has complied with the remaining requirements of this agreement, the parties agree that the school district will be entitled to a declaration of unity status in all areas. If the school district has not maintained compliance in all remaining areas covered by this agreed order during the 3-year period, the Indian River NAACP and the school board will meet to discuss an additional period of monitoring and compliance in areas of such non-compliance, and the school district will be entitled to a declaration of partial unitary status in those areas in which it has maintained compliance.
So as I interpret that, that's why I'm saying, add an additional year to offset what took place as a result
So
of
maybe I could clarify?
Please, please, please.
What we're asking for is to, at this point, at the end of 2 years, add an additional year of equity committee monitoring. As Dr. Warrior points out, this is not complete. There is no declaration of unitary status until the conditions have been met. But what does end in 3 years is, unless we request otherwise, is that the equity committee terminates. We're asking for the equity committee to continue for at least another year.
Absolutely, in my statement, that's what I said, if we meet those requirements. And I would also argue that those requirements, it's a very low bar that's set, and they need to be reevaluated, and we need to have clearly defined expectations placed on us as a system that is not this, attempt in good faith, try these kind of things.
If I could, what it further says, even if at the end of the 3-year period, the parties agree that the school district is entitled to a declaration of unitary status in some or all remaining areas, the Equity Committee will continue to exist and monitor equity issues for at least 2 additional years.
Correct.
So there's a built-in process for the equity. There's nothing that determines that the Equity Committee is going away.
No.
It
Dr.
continues,
Schiff.
whether we request or not, it continues.
Dr. Schiff, thank you for that interpretation. As Mrs. DeGrester's not here, but she was in the room when I was in Miami, and Dr. Warrior can validate, we were going to shut it down. Judge Graham looked at me and said, Mr. Brown, don't get caught up on the 3 years. He said, those 3 years are illusionary. If they don't do what is supposed to be done and the NAACP don't sign off, it's not going to happen. So I thank you, Dr. Schiff, for that clarification.
So can I, as long as I temporarily have the floor, which I'm going to hold on to for a minute, part of what's happening here is that we're collapsing, I think, 2 different things. We're collapsing what are the recording requirements of the joint plan with what is the relationship between the school district and the NAACP. And I think we came into this conversation thinking we were having a conversation about the relationship as indicated in number 2 on the agenda. And where we are now is what do we owe to the court? Both things are significant, but if we don't deal with the former, if we don't figure out a strategy to repair the relationships or to move forward in a way with the relationships, we're going to have this same conversation year after year after year. Because as everybody, I think, has heard, the definition of insanity is doing the same thing over and over again and expecting a different result. I heard a lot in what Dr. Warrior said in her opening comments. And I'm going to go back to that for a minute, because Dr. Warrior, I think you said some important things. Dr. Jacobs, would you mind putting them back on the screen so I'm not talking to that? If we could go, back to Teams. I just want to be able to, see. Well, now it's only Dr. Warrior. But Dr. Warrior, you said a couple of things. First, you said, or you alluded to, that we're making some assumptions about language, about equity, about collaboration, about commitment. My words, not yours. And every time we have this conversation, we're talking about those words as if we have some agreement about what they mean. And I almost feel like at this point we need to slow down to speed up. We need to back up a little bit in terms of where the relationship has gone off, because we're going to keep going in this circle about practices and reports and data without actually getting back to. You said a couple of other things. You said that at some point the African American Achievement Plan and the Joint Plan got collapsed. And so when we talk about reporting now, we've collapsed those two things. And pardon me if I'm mischaracterizing what you said. So I
think that's that's a very good summation of what I'm saying. And that people are feeling impatient to move ahead and do some things. But until we build a foundation, I think this is really a demonstration of just that. What does, this one want? What does that one say? Who does what? How many years do we have? And we're back to not talking about achieving a transformative educational system. We're talking about battling through.
Right, we're talking about court orders and plans and data when we're not actually getting to the foundation on which all of this work occurs. And so you also in your opening comments referred to an experience you had in graduate school where you locked yourselves behind a closed door and talked. Right. Until it was done. We can't do that because of Sunshine. But there are processes that we can use in Sunshine around really transformative community conversations. You and I have talked a little bit about that, but I think there are some ways, because right now, we sort of keep going back around to, we have to report to the court. If we can't report to the court, our choice is to go to mediation, or our choice is to go back to court, back into adversarial processes. But never are we talking about how do we do something fundamentally different that transforms these conversations. I think that's where we wanted to start when we talked about roles and responsibilities and how do we build those relationships. We've talked innumerable times about trust, about collaboration, about responsibility. But yet we wind back in these same conversations. And I will speak for myself only. I feel at this point fairly strongly that yes, we have obligations to the court. We have to do those reports, of course we do. But we also need to really step back, because this conversation continues to evolve and devolve long before I got on the board. And if we don't sort of put a floor on that now, it will continue long after I leave the board. And so perhaps not tonight, because I don't think we have time or capacity to do it. But moving forward, I'd like us to start thinking about how do we have some of those relationship building structures and environments, irrespective of what the court says. Because the issue here, the court is a vehicle. The court is a vehicle to get towards these outcomes that we want. But it also, it can interfere with that as well. And I think if we could talk about some other strategies for how we can get through that, not tonight, we can't do it tonight, but I want to open up that possibility. And I have some thoughts about how to do that we can get into at a next meeting, which I hope we can have sooner rather than later, so that we can continue these dialogues. Because the only way we're going to build these relationships is if we continue to talk to each other. And I know that sounds rhetorical and like I'm pontificating and we use all these words, but if we don't do that, we're going to have this same conversation in March and in June and in September ongoingly. Pardon my getting up on a soapbox here, but.
I'm next.
One comment that came up that I really want to focus on that I think is a crux of our problem, which we've talked about trust, but I think I heard more of trusting the data. And I don't know if we're ever going to get anywhere if we can't say that you're ever going to trust the data. So I guess our confusion, or at least I'll say my confusion, is what data aren't you trusting and why don't you trust it? That's what I don't know.
I've never made, I don't ever recall making a statement that I don't trust the data. I know that people have said you can make data say
wrote it
anything
down.
at once, and I'm not of that school. I'm basically the 1 and 1 equals 2. How we interpret that and how we turn the data into information, because I don't think data and information are necessarily, the same thing. And then how we turn the 1 and 1 equals 2 into some information, and that the people who use the data can distort it and can sort of skew it one way. It's not that I don't trust the data. What I don't trust, and to be specific, is that in dealing with the data, because I mean we're gonna have to trust everything. It will end up being data that we track it. But what I don't trust is when I say that we would like access to as the NAACP, to have the data given to us in a way that we can look at it and utilize it. And we say things like, please don't give it to us in PDF files. Please don't do that to us. Give us something that we can look at your data. We can't, and I hear that, well, the decision was made to create a database that even converts the native format into PDFs. That's not useful for anybody trying to do, compliance and evaluation. And even further, when you're not even giving analysis to the data, the way the information is usually presented to the board, here's some numbers. It doesn't give any hypothesis about how to analyze the data. So I've never made the statement. I'm quite clear that I don't trust the data. That's not my issue. I keep saying, give us the data. We can't even access the data we've asked for, agreed upon it. We can't get it. We can't get it in a format that we can utilize. I thought we tried to work very closely with the district. We were working with Dr. McMahon and Mrs. Dampierre when they were setting up this almost last, because it's changed within the last couple of months, and we didn't even know it, this collecting the data for this year. And one of the things that I talked with Dr. McMahon over the years is, things like and the equity committee told them, please don't send us any more PDFs. That's flat. That's a one-dimensional thing. Give us the ability to look at data. We can't change your data. So I'm not sure why it's refused. And so the database was created in a very strange way. And then this impacts your staff, because they were being asked to not just send us the data as collected in its native format, but there were instructions for them then how to change that data after we'd said it won't be useful, to change it back into this flat unidimensional PDF. And so that's really the message is conveyed, that somehow we're going to do something, or I don't know what the message is about that. But look at it, we can't utilize that kind of data. You're a data person yourself. And so after having a discussion with the district, getting very excited about the fact that we were included in the developing of something that we could need, because it's not just the equity committee, because like I said, the NAACP doesn't cease to exist because an equity committee exists or not. We still, as the plaintiff, are going to be, petitioning the court that these are that these agreements need to be held to. And that's, sort of the argument. So I've never said that I don't trust your data.
Okay, so Dr. Worry, I'm hearing your frustration about, I guess, how the data is coming, correct?
Correct.
Okay, so perhaps one of the things that we can clarify or come to an agreement about is how you need the data in order to interpret it.
Absolutely, and I thought that we had agreed on that, Ms. Davenport, when we were working actually, coming once a month. We had set up once a month to work with Mrs. Dampierre, attended those meetings, and Dr. McMahon, who in the past had been someone that I thought I could at least communicate with because of that language versus the other words. And then I saw that, saying very clearly, that's not the way we can use it. Leave it in its native format, and so that we can do it, because it's not even just about looking at it. It's about, I would think, the way that you would use it. There's some interesting things to do with the data, because one of the things I'd rather be doing than doing this is looking at why are so many African American kids not being able to take advantage of STEM or STEAM programs. And what you look at when you see the data was, in the 2 years ago when I looked at it, because only 29 African American kids in the 8th grade, and you must take it at a certain time. If you haven't completed algebra by the 8th grade, you're sidetracked. You're never going to do pre-calc. You're never going to go these things, and you know that, having dealt with this. And so then if we go back to the data, and what the data is, by just perusing it, is like, well, guess what? Of all the African American 8th graders, only 29 were even in the 8th grade. Why was that? And then we looked back at that, and then I found out, well, the rationale was because you can't be in it if you do something else. To me, that's more important than this kind of, debating that we're doing. But evidently, we're not going to be able to get to that level of looking at the information and truly doing what's right by kids, because we get stuck in these situations. And then when we feel stuck, we start to develop it. Well, you said this on this piece of paper, and you said that on this piece of paper. And I say, oh, no, let me tell you, so the judge. I mean, we can play that game all year. And that is truly not in the best interest of kids that we say that we're in. Because it's something much more interesting to do with data than what we're doing. So that's where I am.
Just a couple things. Talking about data, one of the things I used to do to staff was, what evidence are you asking for that you don't have? That's one of the things as far as, making sure we're qualifying the data. And data is one kind of evidence, I understand that, but there's also qualitative data. For example, the African American teachers that we're hiring, how are they doing in their first couple of years? What are their top concerns? What are the reports from the community? What are they thinking about right now? And even talking to our students who are struggling or who can't get into those classes. I think that's a lot of things we can do as we move forward. I never really worried about the 3-year, August 2018, when we started this to 21, because it did say that we could add additional time for monitoring. And obviously, I think that's where we're headed. And when the new equity committee gets going and the chair is chosen, we could work together, NAACP, the board, and the equity committee. But I want to make sure that when we go forward, that we do not squander resources, that we resolve it. We identify the issue. I don't want to say problem, but identify the issue or problem and be very, very clear before we start that. And I think what I'm hearing is this Friday we could say we need another year, or however we want to word that to the court, because this is this will never be finished. This is something that we need to always work on. Always need to discuss and collaborate and move forward. It's just something that I think we could get started on and have a positive impact.
Doctor, I would like to go back to Dr. Schiff. Dr. Schiff asked a question that has not been answered. I go back and I give him his kudos. Chairman Barefoot, he has done something awesome in my opinion. We sit down and we have conversations. We don't come to the conversation with all the answers. He'll say, Tony, I don't know. Show me, teach me, but be honest with me. That is how collaboration, that is how trust, that is how respect is started amongst people in these type of situations. Don't come in the room with all of the answers. Don't come in the room that and minimize our position or our knowledge or our information. When we can honestly respect each other's thought process and what we all bring to the table, and not come to the table as if I'm the genius, I got all the answers, because you don't. The Bible tells you that you can get knowledge from the mouth of a baby. So for you, Dr. Schiff, I think that was important as to how we start this. And if you take a look at your chairman and how he's tried to work with Dr. Warrior and myself, being open, honest, and having a true open dialogue, we can start to move. I just wanted that to be known. Mr. Barefoot has an idea of how this should be done.
Okay. So we still have a report that's due on Friday.
Well, I think this has been a wonderful discussion, and it's like it's like a foo-foo bird. Have you ever followed the flight of a foo-foo bird? It keeps flying in concentric circles till it flies up its own you know what. We've got to, and Dr. Warrior, I think you recognize that little parable, don't you?
I don't want to agree that I'm as old as you are.
At any rate, well, at least
You're not.
at least we can laugh a little bit. I think one, we've got to decide what we're going to send to the court by the end of the week. And we need to get agreement, not suggestions, recommendations. We need specifics that that the school board will sign off on and that the NAACP will sign off on. Two, we need to resolve, and I don't know whether we have, maybe we have and I missed it, what report are we going to send? Are we going to send the March to September report and then follow that up shortly thereafter with an annual report and then follow that up in a couple of weeks, a month with a March report? Or is there a way to take the January 29th draft that Dr. Moore sent that's a combination of the forced update and the annual report? Is there a way to edit that, tweak that, when we can eliminate one of the three steps that I just mentioned and put that behind us and start to focus on 2021? I mean, it's a question.
I propose something around that. What about something as novel as just telling the judge where we are? That we are struggling, that we have tried some things, that for any number of reasons, you know, we're not there, we've not resolved it. We are technically to the place that it calls for mediation. But we know that mediation doesn't work because it's among ourselves to do this. And say to the judge, here's where we are, this is what's going on, because the status report is simply that. It's not just numbers. It's, you know, I've even asked for, to say, did we do this or did we do that? But we can't even agree to what the this is at this point. And so we're out there. So tell her where we are. And I don't see that she's going to come unglued and you know, ask us for anything we don't have. Just, you know, somebody said it and it just filtered away. We have not been able to come to these things. We are struggling. We have this history behind us. We're going forward. I feel better about that than something that now, you know, we're talking about typing it on the screen. We went through that for the African American Day. And believe it or not, that still turned out wrong because we rushed with agreement. You know, and we do need to move some things ahead while we clear up some relationships. Because until we repair the relationships, I'm with you, that we're not going to address this, and hopefully we can make quantum leaps. Because I'm also not, you know, an agreement that we take another 2 years or 3 years or 10 years, because you know, to make any significant, you know, changes to the court. So what about just, you know, simply acknowledging where we are, the good, the bad, and the ugly, or the good and the bad, or something you said, Dr. Moore, when you first, you know, within your first month or so, you know, at the district. And that's all we ask, because when we hear things like, you know, gee, you know, we rank here and we rank there and we rank high in the graduation rate and we're a world-class school. And so then, you know, you would say, well, what's that based on? I mean, we didn't do this, we didn't take into consideration. And so things don't seem genuine, don't seem authentic. Let's just be out there. Let's do what we say we're going to be, you know, expose our issues. We don't have to call them problems. There are issues, our challenges. We're not the only place struggling with this in the country. Maybe we could figure out a way to resolve some of these issues, you know, that would truly make us a leader in some area for you know, districts moving forward. But let's lay it out there. Let's be honest and say we're not requesting mediation because we know we need to do this and we're not giving up. And I think the judge would appreciate that, because the judge doesn't want to be, you know, King Solomon in this and split the baby either.
Dr. Warrior, you know, I completely agree with you. I can't speak for my fellow board members. But and I would add to that, that's a good thing. You know, we're characterizing it like it's a bad thing, but the acknowledgement that we're struggling, the acknowledgement that we're working towards this, the acknowledgement that we know we're struggling, but we're committed to working together, to do this outside of mediation, outside of going back to court, I actually think can be framed in a way that, well, we would like to be able to say we've got the great data and we've resolved all these issues, but the fact is we've never actually directly acknowledged this before. And in acknowledging this, we acknowledge that there's a place we need to start, things we need to do that are fundamentally important. And I actually think that's a positive thing, not a negative one.
I agree. And I mean, just in general, honesty is the best policy. We're struggling. We all want to move forward. We know we want the success for our African American students, and it's something that we will continue to work on. Like I said, I don't want to go to mediation. I don't want to have any kind of court cases. I don't want to spend another penny here. I think we can work it out together, as we move forward, and just do the work and do our best each and every day.
And I would add that Dr. Warrior in her initial conversation extended the olive branch. And I think what she said is the best step moving forward. Judge Kathleen Williams is not stupid. She's had a taste of our dysfunctionality already. And I think if we honestly approach her, letting her know where we are and being open, transparent, and she will say, okay, they are moving forward with just the fact that they're trying to now listen to each other and accept each other's perspectives, opinions, and points of view. So I think we have a place to start, and it's with open and being honest.
And one of the things I'd like to say is we approach this as though somebody's got to win and somebody's got to lose. The only people that are going to win or lose are ultimately the kids.
That's right.
Our kids.
That's right.
And we're feeling desperate about that because I'm not seeing the numbers in the same way that they're looking good for our kids. I mean, that would be inconsistent with the data that's been found anywhere else in the country. And so to have these discussions and look at the interpretations and what pieces are missing and what are not, and it's not about the district looking good, that we only publish what makes, because, in one instance we say we're going to discount the 2019 data. But then when the thing comes out and shows that graduation rates have gone up, well, okay, we'll look at that and we'll accept the data that says that we can't. I mean, that just gives the impression that that the district is going to say, we're going to only accept what makes us look good. And that's not what you promised us, Dr. Moore, when you early on in the book. It's that we're going to look at the challenges and our struggles and our willingness. And people tend to say, oh, you're so negative and you never have anything positive to say. Well, I mean, we can come to some place, but we get all lost and we mouth the words about caring about what happens to kids. And yet we continue the generational stuff of kids not being able to read at grade level. And those numbers, and if we are indeed that out of, so much different in that than the rest of the nation, then I want to look at it. We should bottle it.
If we all can take a second and just digest that, does that accurately capture the conversation that we just had in terms of being open and honest regarding that current reality? It's not specific, but as I write what would be a very, very brief letter to send to you tomorrow, Dr. Warrior, can we norm on the language that is there, open for dialogue or conversation, or let's redline and do what we have done for the last 6-7 months in terms of creating a document? It's just something to norm my work for tomorrow. Can I add something? Yeah.
I would actually. Oh, wait a minute. Okay, now I'm on. I actually want to emphasize that this, in its acknowledgement of this, acknowledging that we don't want to be adversarial with each other, but is actually a good thing. That having reached this point, we've gotten to what we think may be a foundation of our constant disagreement, because we haven't dealt with this, and actually acknowledging it moving forward, we think is a foundation to actually work well together in the future. I didn't say that well, but that's the idea. And I open that up to you, Mr. Brown and Dr. Warrior, whether you may or may not agree with me, I don't know. But I actually see, conflict is not a bad thing. Acknowledging that we have conflict, acknowledging that we have disagreement, and acknowledging that we're committed to working through it productively, collaboratively, however we define those words, I actually think is a very positive step.
I would agree to that, and I'm watching you type, and I almost want to say to you, Dr. Moore, don't do anything else. No, in terms of it's okay, because we've gone through this process. What I say is, my feedback is it looks good. What I'd ask you before we move into some commitment, because I've seen this come back to bite me in the rear end time and time again. It looks good at this point. Can I sleep on it? Can we just take a minute to catch our breath and make sure that we've said what we have to say and agree tonight that tomorrow will be soon enough for us to sign off on this? Because as I said, as you know, Dr. Moore, we tried this around the African American Improvement Plan, and it still will boomerang on us. But right now, I think it is, and I think the only way to move forward is to continue to have some of these painful, agonizing discussions and be able to stop being a dysfunctional team.
And I would suggest that we keep this as generic as possible, and not getting into the data and so forth, because it is something that we want to, we teach our kids conflict resolution all the time, so we can do this.
Right. I don't think we need to get into the details. Like I said, I have my concerns about the data. I know, Dr. Moore, you've acknowledged in the last that I had, concerns about it. That we talk. I thought we were sort of developing ways to move forward, and then I too am surprised every time we seem to step back. And so let's not try to put a lot of this. We won't include specificity. Let's just include what we really. I mean, if people do, agree to this making sense, because it's not just a matter. And I always kind of wince when board members turn to me and say, "Okay, what do you want in NAACP?" As though it's not. What do we want? Let's talk about this, because then it seems like it's on us, that somehow it's our problem, or it's ours to figure out, or we're the problem, versus a collaborative kind of thing.
Can I guess everyone is in agreement with that statement, but I would like to go back and ask the question, because I don't know that I'm confused, but I'm uncertain. We still owe the court a report for a period of time?
I'll give my answer and then defer to Mr. Brown and Dr. Warrior. So based on my interaction with the court, if we submit something that is open and honest regarding the particular reality, and this is the collective priority to establish this trusting relationship before we can consider creating anything. And so I think if we told them, this is where we're at, these are the frustrations that we're experiencing, and this is the collective agreements to continue these conversations, to establish the trust and build the relationships, at which time then we'll continue to submit what would be the next series of reports. Now, that would be my recommendation. I think we should also include that we're going to establish the equity committee and allow the equity committee to begin its next process. I think, based on what Mr. Barefoot has told me, we're on consensus to get the equity committee up and running. So I see it as telling this is the truth, this is the reality. We now come to consensus, and I agree, it's not a lengthy letter, that trying to create the update prior to establishing a foundation of trust and going through the process to get to trust is going to lead us to mediation, which Dr. Warrior said is not where we want to go. So giving them this reality and saying, we'll submit these reports, in March.
Well, I think he read that we can agree on a timeline, but I think what it will do is we set this for ourselves, that we do want regular meetings, that we do want reports, and we need to develop, sort of say, we'll give you the updates, we'll give you the progress we make from the last meeting in December to this meeting to, the subsequent ones, that the reports don't become such a strange thing out of there, but they become more, more demonstrative of who we are, and we don't see them as tasks, because it's our own way to reflect back on what we're doing, what we agreed to do, we're moving forward. And so it doesn't become this onerous side thing that we do.
I couldn't agree more that as we have these meetings, we provide an update, it becomes more transparent, open, and honest versus a static 6-month report. That would require us to notify the court of a change. We're collectively agreeing to this change on the joint order. And I think that might be something we talk about in the next meeting, that this is working better for us.
But here's a question. Let me turn this on. Here's a question. This is all well and good for us, and the judge will like it. But do we have a legal obligation to give a report? Or, and this is a question for you, Katie or Ms. DeAgresta, do we have a legal obligation, or can that be waived by sending along what we've agreed to here?
Maybe I reframe that for a little bit, if I may, Mr. Bedford, and maybe say the same thing. We're not asking to waive reports. We're asking to be able to provide reports, which I think the court would say, that's what I always ask of you, to simply report to me your progress towards what you're trying to do. What we're now doing is submitting this, as in response to our progress, which is that the judge is more concerned, I do believe, and you ask the legal opinion if you wish, it is that the judge is more concerned that she not be asked to split the baby, that she is going to say that you are under a DSIG order, and there are some general requirements around that. But the most important thing is that we agree to something, we work out something, and we do it in a given time frame. We can commit to how often we're going to do our own reports and think of them as to ourselves. So I'm trying to talk you out of something that doesn't answer your question, but I just was throwing that in, that we're not asking to not report. We're going to report. The report is, from what the judge has said, is progress towards the joint plan, and so progress towards achieving unitary status and going a step beyond that to transformative education, or, whatever name that we're using, is a part of it. And so you can ask.
So can I, Dr. Warrior, can I just paraphrase what I just heard you say, and let me know if I'm on target or not? That this update would serve, this is the update that we provide to the court regarding where we currently are in its truest, rawest, open and honest format, which would serve as the 4th status update when we meet again, which would be prior to March. We provide an update once again, kind of summarizing that meeting and that progress that we would take, and continue to provide those correspondence aligned to what would be the 5th, the 6th, 7th, and 8th status reports.
If I'm following, I'm a very visual person. That sounds right, that this is our report towards progress, towards, obtaining unitary status, and we're not just going to say we're going to do it at any time. Then we agree to a time frame that we think that, will we do this quarterly? And when we take stock, what we take stock in and how we talk about what we did is the report. That it's not something that people see it onerous because it looks like it's piled on top of everything else they have to do. But if we're truly trying to transform the system, this is what we would be doing. We would be periodically looking at what we've done, acknowledging what's, is true. Some of it's going to look great, some of it's not going to look so good, but it'll be just like the model. We'll learn from it, we'll build on it, and that's all I think that is being asked. Now, I do ask that that it's not completely stalled, because even though tonight we're stuck back in September, the half of this year is over with almost, and some things have been changed, and there's some things that I want us to discuss about how we're collecting data now, whether that's going to truly be evidentiary, that is evidence. I mean, so the system doesn't stop. We just have to be able to think on at least a couple of levels at the same thing in time. And I think you can appreciate that, Dr. Moore. I mean, we haven't stalled what you're doing. You've done a half a year darn near already.
So just
Dr. Moore.
one last point or question or comment. I suppose when this goes to the court, if the judge doesn't like this being a substitute for what she expected, then I guess we'll hear about it.
Right, and this isn't a substitute for. All the joint plan says is we must provide reports on our progress. It doesn't say we have to provide data. It doesn't say we have to give percentages of kids who are being suspended. It says we need to report on our progress. So this is a report on our progress. I don't think, now, I'm not the judge, obviously, so, but,
Okay.
but this is not inconsistent with what the joint order requests.
I hope you're right.
I think it's worth it. I think it's worth the effort. What's the worst? I mean, you know, what's the worst case? I really do. I don't think the judge has an agenda separate than ours.
Dr. Warrior, Mr. Barefoot, Dr. Moore and I were the only two people in that courtroom. Mr. Grest is not here. She told us, let her know what the bumps in the roads are. Judge Williams wants this to work. I've stated over and over, this was a framework for us to work in collaboration to get the work done. If this is something good, if we all mean what we're saying here tonight, and Dr. is correct, let's give a report. It does not have to be statistics, data, and all of that. Let Judge Williams know, as you were there, Dr. Moore, she's a straight shooter. Let her know what we're doing, what we're not doing, and that we tonight have come a mile versus where we were yesterday. So we don't need a legal opinion. Only you and I, Dr. Moore, was in that courtroom when she went off. So I think we're in the right place and work this out. And Dr. Warrior has the authority of me and the executive committee to help this thing move forward quickly.
I agree with Mr. Brown from the conversation in the courtroom with the judge that a document that captures this conversation, the last 15 minutes of this conversation, would suffice as the fourth update. The only hanging chad that I have would be the annual review or the annual feedback. And I don't mean to muddy the waters, but
Well, I just, about 10 minutes ago, asked Katie for an opinion, and everybody's been talking. So would you mind, everybody else has offered a point of view. I feel comfortable if we can hear from you or through Ms. DiAgresta. The question is, from a legal perspective, not this collaborative agreement we've come to, how does that match up with what is expected by the court?
I would agree with what everyone said about the status reports. I think that's kind of loosey-goosey. There is a provision in the judge's order that states that if we have any disagreements, we shall go to mediation. So that's something we should keep in mind too, that the judge may say, look, I view what you've given me as a disagreement and you need to mediate. So that's just something to keep in mind. But I think Dr. Moore's statement about the annual report, that is a different animal because it does provide that we're to give information regarding the status of our progress in achieving unitary status, which seems to be a little more specific than the joint status reports. So we do have to be mindful of that.
So I would just read directly from what the order from 2018. The parties shall file a joint status report every 6 months advising on the progress of the goals set forth in the joint plan. I think this documentation captures the progress that we would collectively agree upon because we're advising the court. The parties are filing a joint status every 6 months advising the progress of the goals set forth in the joint plan. I think this accurately captures that. It is vague, but that's what was ordered. That's what we should do. In terms of the annual report, yeah, that's still out there. Give me a second. By all means.
Something that I think that we ought to add to this, which is on our agenda, are the roles and responsibilities. One of the reasons why I think we should, before we end tonight, definitely get to the roles and responsibilities related to the joint plan of everybody involved is so that we can be sure to add it to what we agree are the roles and responsibilities and set up the understanding that we're all on the same page with those roles and responsibilities, specifically because the Equity Committee is soon to meet. They need to understand also, even when they rewatch this back, what their role and responsibility is as being a board committee, right? So I think that's something that we need to discuss before we leave tonight. But with that being said, since the Equity Committee is meeting soon, our annual report is due in March, is that right?
No, it was due this past December.
The annual report.
Yes.
Okay, so we
Second
are
Monday.
late on the annual report. So disregard what I was going to suggest. What I was going to suggest is to ask the court for a little bit more of an extension to give the Equity Committee an opportunity to meet so the Equity Committee can provide feedback so then we can all come, even if it's just one meeting, we can all come to consensus on our goals moving forward and include our 6-month, Dr. Warrior, this comes back to the original 6-month report on the goals. Include a consensus, come to consensus on what the 6-month goals are with the input from the committee, and include that in as well, an annual report to the court. Though a little late, it's still substance.
So my,
What are her thoughts?
Dr. Warrior, do you have a?
Yes. Oh, I'm awake.
Well, if you had any feedback, I think the recommendation is to provide this information as the force status update report, and then I'm paraphrasing, so let me know if I'm not capturing it correctly. And then allow the new equity.
Include the roles and responsibilities.
Including the roles and responsibilities. And then allow the incoming equity committee to conduct that feedback.
To help provide feedback for setting goals and provide that feedback within an annual report to the court.
I have,
Well, first of all, I would need to see that, because and this is one of the things I said, the more simple we can keep this, the quicker I can say now we've added a thing. And I think it sounds reasonable, but I'd need to see it written out and see what that looks like. And like I said, and have a minute to think about it, because otherwise, I'm fearful that I missed hearing something here. That was a little more complex
I also,
request.
if we could, I want to be,
I would like that.
Or let's hammer it out now.
So let me.
I would like to add something.
Go ahead, Mr. Brown.
Mr. Barefoot stated, we need to encapsulate what we're doing in one area. We keep jumping around. I think getting this, what you were working on, and Dr. Warrior into the courts itself is paramount. Rules and responsibilities, and combining that with the equity committee, first, let's let Dr. Judge Williams know that we kind of pulled our heads from a place and are now starting to work as a unit and trying to get some things done to give us some breathing room rather than consolidate all this stuff and give her too much to think about and then worry about the rules and responsibilities, not to her, but among us.
Okay, but I
That
think,
makes any sense.
well, I think we can build it in, and that would make, because I agree with Ms. Massari on things, this, if we could keep this simple and say that, because we're saying we're already in the, a few weeks away from the next report.
Right.
If we could build in what Ms. Rosario said, if that means her writing it out or something, if we can build that in as something to be addressed, because I think we do need to move rapidly on some of these things.
Yeah,
And what she said, and the roles and responsibility discussion needs to occur, I think, before the equity committee is charged, because we won't know what to charge them with. And so we just know that, just say to ourselves that we're going to commit to within a week that part of this report be that part of our work in the next report, which will be coming up very soon, is we will have resolved these issues, and that will still not, delay the equity committee from doing whatever they need to do. Because does that make sense?
I think we're close. I just have a level of hesitation about leaving hanging chads for the year 2020, and I would really like the equity committee to start fresh going into the new year. So when I look at the joint plan, the recommendations which would come from the equity committee are demonstrating the progress that the district has made within each of the sections as it relates to unitary status, whether it be whole or in part. One, if we include into this update, based on what took place on 2020, we agree that we're not making any assessment that unitary status has been achieved within any section, and that would serve as the function of that progress. So we're acknowledging where we are, fourth status update, and give a very honest reflection as to where we are or where we currently aren't but accurately capturing that. And then we begin with the equity committee, setting them up for a situation of success. And then our very next meeting is a tighter agenda where it is roles and responsibilities. I think the roles and the responsibilities of the equity committee is, I think we're in a good place there, but continuing to norm on our relationship and our expectations of each other between the school board and NAACP are our opportunities to improve. So as I say that, any feedback, Dr. Warrior, Mr. Brown?
Yes, I have some immediate feedback to that, and it does relate to Mr. Rosario's stance of needing to set some roles and responsibilities. And what I say is the equity committee, again, is a committee of the board. The equity committee can recommend, and I guess you co-opt 2 NAACP members, but basically the NAACP does not give up any rights to the equity committee. It is not a committee that we control. And so that anything the equity committee comes up with, even though we have 2 people on it, which doesn't, is that they recommend things to the board that you can accept or not accept. You could set it up now if that's clearly understood and established, and that does not mean that the NAACP, because then it comes to an agreement. The board, they will recommend things to you that you will accept or not accept. They're your committee. I mean, we could technically, I guess, set up that kind of committee in the NAACP, but we do not give up our. We're not going to say that whatever the equity committee comes up with, being that they are board, a committee of the board, that we're going to agree with it. And I know that may sound strange, but you can't use a committee that you co-opted, and I don't mean co-opt in a bad way, but we've agreed to put 2 members on, and yet believe that once they evaluate or make, decide that there's no question that we're agreeing there by what, what is agreed upon by the equity committee. We won't agree with that. There is your committee, they'll report to you, they'll make recommendations, you can do what you need to do. The NAACP will do what it needs to monitor, and that's why I said the old discussion about access to data and some other things come up. But we don't give up any right to continue to be plaintiff in this case. The equity committee does not sort of supplant us in any role or responsibility that we currently have. And here we are right back to the role.
I think we understand that. Mrs. Berenberg had a point.
Can we agree that the equity committee's role and responsibility is to meet, review data?
Well, we haven't gotten there yet.
Recommendations to the school board?
We
I
haven't-
can't, I'm sorry, I can't
He
hear
has
you,
to
Ms.
go over that.
Berenberg. Could you speak a
Haven't
little bit
gotten
into
there
the mic?
yet.
What? No,
No, she wrote it up there, but we haven't had an open discussion.
that's what I'm saying. I'm trying to start that discussion, Jackie. I'm trying to say, let's do it. Do you agree that the equity committee, this is their role and responsibility, that they meet, review data, and provide recommendations to the school board? Do you agree with that?
Yes, I'm okay with it, whether
Okay.
I agree with it, I have no problem.
Is there anything
Because
else that you want to add to that?
I think they
To
reviewed
the
the,
no, it's what the joint plan says, and all I said is,
Right.
to
The
what
joint
extent it
review
is not our
the-
agreement that somehow supersedes the role of the NAACP.
review the progress made.
They are a committee of the board when we read the joint plan.
Okay, do you want to
Even
change
though
that,
we
Dr.
have
Moore?
Sorry.
No, I think as I was saying, I think the equity committee is relatively spelled out explicitly in the joint plan, and I understand what Dr. Warrior was saying. The equity committee meets, reviews data, reviews the progress made related to the each section of the joint plan, and provides recommendations to the school board. I think that accurately summarizes the work of the equity committee. The question that I pose is, can we agree to inform the board that we collectively agree that we are not making or reporting that the school board has made progress towards any partial or full progress towards obtaining unitary status in any sections of the joint plan during the 2020 school year. And if we agree on that, that is a quick two-sentence summary of the annual progress. We're saying, you know what? This year, we did not make any progress towards obtaining unitary status, whether it be full or partial, in any areas of the section. That closes the door on 2020 in terms of the annual report completed by us, both parties, and closes the door on the fourth status report. And then we can begin the work fresh in the current year with the new equity committee and really pull our conversation forward into the reality our students are facing today.
I want to go back to what Mr. Brown said. When we started this, basically we were saying, we haven't come to an agreement yet, but we're going to work together collaboratively. We're going to move forward. And now we've gotten into a lot of details. So is that where we wanted to go? Did we get into the weeds a little bit too much on this? I'm thinking the judge would say, hey, if these two entities are working together and they want to move forward with all this in mind, or did we go into more description than we really intended in the very beginning?
No, go ahead, Dr. Warrior.
I was going to say that I agree that as we had something and that I thought that set us up. Now, as we add more and more to it, I think we're getting into something that makes me particularly, given my experience with agreeing to these things, that I'm hearing all of this. I need to see that in writing. I cannot leave here tonight if we make this longer and longer and longer and say, yeah, that's what we agreed to. What I can agree to is within 24 hours after we hear or something I agree to, that we can do it. But I need to read this now and process this.
No,
I do too.
I agree. And the only thing that should be up there and we're trying to summarize what we said, so this should help move the work forward, is a very brief statement regarding our current reality, where we're currently at, the frustrations that we're collectively experiencing, and our commitment to continuing to have conversations, because we know that is the pathway forward. That is our fourth joint status update. Very succinct and to the point, capturing what is the truth of that reality. I think I can pin that. And Dr. Warrior, and go ahead, Dr. Warrior.
I was going to say, and the rest of this that's been written up there, maybe this is just, if this is touching what you were talking about, Mrs. Rosario, that thing we then talk about, and here are the things we're agreeing to look at the next meeting.
Yes,
and
no,
come to
yes,
some consensus on.
I agree with that. And then the other thing would be the annual report that we collectively agree that there's no progress towards partial or unitary status within the calendar 2020 school year. And then our next meeting would focus in on what's scribed there. That's it. It is a one-pager.
Okay, and I would ask you that it seems to be a very important part, which for me makes me wonder, okay, what are you saying here? Let's have that discussion a little more, because that seems to be very important to you.
I'm sorry, Doctor, can you ask that question again?
I was saying that part about what we do with the annual report and moving ahead seems very important, and I'm not quite sure. I would like to understand a little better why that is so important to you, that we close this out and do something, whatever your last
my thoughts are, and really to focus the conversation not in a backwards view, but really in a forwards view in terms of what we're dealing with now, the current reality. I want to force the intelligence on this call and in this room on our current reality, because we're facing extremely big problems that we need to push ourselves to tackle. And meeting again, to go back about the annual report, if the next time we meet is March, we're going back and looking at information from what would be three months old. So I'm trying to, the judge wants progress on unitary status at the end of every year. We can concede that there is no consideration for unitary status in any area for this particular year. And that's why I think it's important. You know how I feel about the volume of work that's been done. But I'm willing to concede for the benefit of moving this work forward and building a strong, trusting relationship, engage in the here and now, which is more meaningful and fruitful conversation, because it's going to have a better impact on our current students in our classrooms.
Okay, and that's the part that concerns me, because now we're starting to open up a larger discussion around it. Because you said the intelligence in this room, I guess I feel like, while I'm having this discussion, I'm also looking at your database for this month, that we have enough intelligence in this room to sort of realize that we are balancing two things. Because when we get into, I don't want to look at three months back, is a place that I just fundamentally disagree with you, because any evaluative process requires looking back to see. And so then we're getting into we're opening up another whole issue that takes us back from responding. And that's the part that for me seems, sort of innocuous on it, but it's a fundamental piece for me about how we do use reflection. I don't see our ability to just clean up everything at the end of the year, but that's a larger discussion, but one I think that is very integral to how we progress. Because if we can't reflect on what we agree to do, this is at the heart of the old. Then where are we? I mean, how do we know when we're making progress if we don't have, if we don't agree to some things we're going to look back at 3 months? I believe that we are capable of balancing, that we are not as single-minded as that, because I've already got feedback for you about, the current school year. So that's what I have more concern about.
Dr. Warrior, it's a little hard to hear you in here, so I want to say what I think I heard you say.
Okay.
What I think I heard you say was, well, we may be agreeing that we haven't achieved unitary status this year. I don't know if I can say this well. But what's unclear is what would be the measurement that we had achieved unitary status and that we still need to talk about that. Is that right?
Right. What I'm saying is that we were going along, and what I noticed was that Dr. Moore clearly wanted that in there, so I knew it had some great meaning for him. And for me, the agreement about how we look back, whether we can close out a year, may seem small to many, but what I'm saying, that's actually very fundamental to what got us stuck back in September about what we were going to do, and say, okay, that's all behind us now. Let's start a new and afresh. We'll never be at that place where we'll start a new and afresh. We'll always be looking to some extent back at us to say, well, what did we agree on tonight? Did we? So that piece, I think, requires further discussion before I'm willing to just right now sign off on it, because I think it has greater implications than it sounds on the surface.
So if I could paraphrase that in a sentence for Dr. Jacobs, who's taking notes, tell me if this is accurate. Wait, I'm not sure I can do that.
Okay, let me try again.
Okay.
I'm not willing to commit to what, to say this is what we're going to commit to around the annual report or anything, because that's not what we discussed tonight. And we're getting, it's far afield. We haven't dealt with this one issue. Let's get something resolved and then talk about that we're going to we need to do roles and responsibilities and that kind of thing. And I'm not willing to concede at this point that means then that we're going to close the books on last year and move forward. There are greater implications than that.
So at the next time, so when we meet in the future, we'll discuss roles and responsibilities, and we'll discuss the clear outcome measures that we're looking for moving forward, so that to review progress from last year?
Right, because we haven't included that, the sort of KPIs that Mr. Barefoot talks about. It becomes very difficult to reflect on and to monitor, because the very thing is we don't have clear outcomes that we've decided. At some point, we need to put those in there. We're behind on a number of things, and somewhere we need to introduce that whole idea.
Mrs. Rosario.
Thank you. But that's what we talked about in December, right? Our annual, I think, Dr. Warrior, I think the concern with regard to the annual progress report is the timing, because it was due in December.
Yes.
And we're in February. If we don't get the court something, who knows what the courts may say with regard to us not complying with that. So we've got not only do we have the 4th joint annual report, which we are writing up the notes for all of us to be in agreement on due Friday, but this annual report, which was due in December, is quite late at this point. So I think that's, I can certainly understand the concern. We met in December as again, collectively to discuss that. And that was one of the agreements, was because of the timeline to kind of bring it together. But without going around in circles, I'd like to come back to the roles and responsibilities, because if we're going to agree to the roles and responsibilities, we need to talk about it. So Mrs. Berenborg mentioned the equity committee. It's written up there, the roles. It's very succinct. Obviously, all of the roles with regard to all of these entities are within our joint plan. But I would like to add the role of the school district here, that our role, and I have it written down, so bear with me. My pad just kind of closed on me. That the role and responsibility of the school board will work collaboratively and cooperatively toward the shared goal of achieving a fully desegregated school system. or will work toward the shared goal of all of the goals indicated in the joint plan. Either one of those, but we do need something written down.
And you're asking me, can I agree to that tonight?
Yeah,
Is-
because we
is-
agreed that we would submit that with our current fourth joint report.
So is the board corporate asking, I mean, see what we're doing, I feel like, again, is the same thing. You're suggesting a recommendation, does the rest of your colleagues agree to it, well, my executive committee, because we have started off, and I thought, in a really good place. Let's do something as simple as we can to be responsive, that accurately reflects both, not just, this isn't something just we're doing for the board. This is something I feel like we're doing is more for ourselves, I mean, to the court. This is something that I feel like that I want to see us do more for ourselves so we can move forward. This isn't to meet just the requirement of the, this isn't a checkbox for me.
No, I know. This is why at the beginning, when we first started this meeting, you said the very top items on the agenda were very important for us to discuss. I'm trying
Right.
to bring us to a close on some of the items that we agree on. Several of the
Well,
board members indicated the same thing when I brought up that we need to add to this the roles and responsibilities, not only for ourselves before closing this out, but also for the committee that's meeting soon, when they watch this back, that they understand that we're on the same page with regard to the roles and responsibilities of each of the parties involved.
Right.
You were in
And
agreement on that.
Right, in respect to that, and what you're trying to do, all I'm saying now is this document gets longer, and I hear these, because when you read that statement, it sounds good, but we're back to the thing that words mean seemingly different things to us, and so that we would not be err on the side, in my role,
So we could
as
just work collaboratively and
talking to the
cooperatively
equity
with the
committee,
NAACP.
is that I not sit here and agree tonight to something that now I need to see in writing, because it's become a lot more than what I thought we're going back, we're doing too many conversations, and I'm having difficulty tracking them in a way that tries to keep us from agreeing to something that I look at and say, but wait a minute, because we've jumped back and forth. We haven't stayed on with our goal, and I'm not even saying that's wrong. But like I said, it needs to be, this keeps getting longer and more complex, and it's a discussion that needs to be had. Is it one that I'm ready to commit to now as we add on to it without, at least 24 hours to look at it? No, I'm not, because I don't want to put us back in the same place of being, reviewing it and not. So,
If I can interject here, I think we're taking something that's complicated and
Yes.
making it even more complicated.
We started
Somebody
out
said,
fine.
let's keep it simple, stupid. I think we're not that we're making more of it than we should, but we're making it more perhaps complicated. Frankly, I think we did decide what the roles and responsibilities of the Equity Committee is, in that it's responsible to the school board for evaluating and providing feedback to the information we give them, much of which will be data-driven. You all, the NAACP, will have the opportunity, obviously, to see the same data, offer commentary as you see fit. But I think it's pretty clear that if it's an extension or it's connected to the school board, I'm not sure what the right word is, and its responsibilities, as I just described, it's pretty clear.
Yes.
And I think it can be quite constructive. And by the way, we have the Equity Committee tentatively scheduled to meet next Tuesday, a week from tonight, and to get them going. So I would, if nothing else, would like consensus that we're going to go ahead and have that meeting, or they're going to go ahead. And that meeting is chaired by Mr. Brown and myself until the 4 members select their chair, at which point in time the chair will take over and run the meeting.
I could agree with that as long as you acknowledge this is a meeting of this is a committee of the board, because technically that's what staff would be doing, whether our people were there or not. They'd be giving you this feedback, and you'd be making, and then the board and our executive committee would come together and and do something with it. But as long as it's, as long as it's a committee of the board and it doesn't put any restrictions on us, such as one of the last things I asked when I asked for a piece of information, it was told, you need to make that request through the equity committee. No, we don't. I don't agree to that as the NAACP. And if that's a sort of roles responsibility thing we need to clear up, I need to hear the board say that we have the ability to access information that we think, well, that's, as long as it's related to the work we're doing, and we shouldn't even be asking for different information. But to say that we as the NAACP now can only go through another committee of yours is simply a hurdle for us. If we can come directly to you and talk to you, why do we then need to go back to your committee to ask them to ask for do you realize how convoluted that is, that process is?
I just want to repeat what I said earlier, and I agree with Mr. Barefoot. I think we're getting way too detailed on this. Again, I was very excited that we could move forward and collaborate and get going with the equity committee. We're all in here for the same reason, for our African American students to have high achieving students. And I really think the judge will, I may be wrong, but I really think the judge will respect the fact that, hey, we've struggled, we know it, we want to move forward, we want to collaborate, and she may ask for some of this stuff, but if she doesn't, she doesn't, and we just move forward.
I agree with that. And then as we start now making it longer and longer, that's where I get concerned, because it becomes more complex, more of a complex document, as you like to say, Dr. Moore. And so when I'm saying, given the complexity that I want to give it to us, I don't want to agree to something that's more complex than it appears. Let's keep it something simple, stupid, or stupid me, that we can agree to, that we can stand by, and that maybe we have to agree to have more regular meetings to iron out these things. I'm not saying there aren't important things to iron out, but we just need to get from here to the Friday agreement. And it's too bad that we didn't do it before, but the reality is we didn't. And so I don't want to create something now that's so complex that we can't live up to it in the future. Let's keep it simple. Let's keep it simple. But not, we won't discard this. We don't ask whoever's taking these notes to throw it away. It's just put it to aside. And then when we could get it to our next meeting and say, okay, old business, then we pick it up.
I have, for the last hour, a summary in my head. It's very specific and captures or is reflective of everything you just said. So not trying to make it a big, long, complex document, a document that captures the truth of where we currently are. And the only other thing I was trying to include, which was not agreed upon, was that at the end of year report acknowledges that there's been no progress towards unitary status in any of the section, which is in fact the annual report. That's the report they want, and if that's the report that if we gave them that would move the work forward. In terms of evaluating and everything else, that's not something in the plan, but I can capture very succinctly the conversation that we had tonight, which would fulfill the fourth status, and then let them know that the annual report is forthcoming as we continue to have these conversations.
Right, and it may be as simple, in our annual report, we may be able to turn around in the next week, to a few days after we do it, when we say there's no compliance with it, so this is where we need to go. Then I agree, that's quite simple, and then we can get into this. But let's just get the annual, the fourth status update out of the way, and then I'm not saying we have to wait 3 months before we get to the other, but it'll probably write itself very quickly given the discussion we have tonight. Maybe we'll be able to make a quantum leap. I think we will, because I don't think the judge is going to ask us. We just said that we didn't. Yeah, we're talking ourselves back into a muddier spot.
I think it's a straightforward report. From the district's perspective, we will reporting that we've made, based on this year, no progress towards achieving in unitary status in any of the sections. And if the system is making that assumption, then I think we should be able to really move the work forward.
Yeah, I do. I think that we're not struggling around those kinds of issues. You know, it's on the basis of it, it's real simple, and as soon as, you know, yeah, I think.
If I could say that. Okay, so I'll turn it back over to Mr. Barefoot and Mr. Brown. Progress, absolute progress. If you're asking me, I think this has been a fruitful conversation that's moved the work forward.
I do too, and appreciate it. And what I'd like to say again to the chair is that as long as that I still request that it appears that we are in absolute agreement, but I respectfully request 24 hours.
I know.
To see the document or 36, you know, something to make sure.
You will get it in the morning.
And Katie will not submit anything.
And one last thing I just want to confirm with Mr. Brown in particular, and all of you, but Mr. Brown in particular, that we're going to confirm the equity meeting for 5:30 next Tuesday, the 16th. And that whether, Mr. Brown, you can be here in person or via Teams, you can chair the meeting, we'll share the chairing. They'll have the vote, they'll have their nominations and select their chair, and then you and I can step aside and they can have at it.
Mine would be virtual by orders of the National NAACP. We cannot do in-person meetings. So let's go ahead and formulate the equity committee.
Okay, well, we can certainly share the responsibility, you being on Teams and me being here. Thank you. Well,
I'd like to also add before we go, this is to make sure that everybody understand the executive committee. Dr. Warrior is my special assistant. All roads in this matter travel through her. So just wanted to make that aware to everybody.
Very good. Well, I echo what Dr. Moore said. I think my colleagues on the board would agree it was productive. It took us a while to get there, but sometimes you have to repeat and repeat and repeat, and pretty soon you get to where you want to be. So we've made progress, and I thank you for your time, and I thank my colleagues for their time. And unless somebody has something else, and I'm even reluctant to ask, I will declare the meeting ended at 9:10.